No. I can see that. Could you ask, could I ask members to return to the Assembly, because at the moment we are not for it. We've got one online. I'll give them a little bit longer. Just can I give members a final warning before I call a roll call by the buttons? Could members please return to the Assembly because we are not quorate.
One online. We're okay.
Well, I gather we are now quorate. But before we resume the debate on the third amendment to the Animal Welfare Law, I would remind members that certain standing orders would have the effect of a proposition being withdrawn if they are invoked. And the standing orders are bear with me. Yes, the standing orders are Standing Order 72, which is the referral of a draft law or regulations for scrutiny. Standing Order 79, which is the suspension of the debate for the purposes of scrutiny. Or Standing Order 85, which is moving to the next item. If any of those standing orders are invoked, this being the last sitting of the Assembly before the elections, then the effect would be that there is no possibility of the debate resuming on that proposition or regulations before the election. So the effect would be that the propositions would be deemed to be withdrawn.
Sir, could I ask for further?
Yes, Minister.
If a proposed law was not proposed in the third reading, would it have the same effect all the way?
Yes, it would have the same effect, Minister.
And sir, can I also have a point of clarification or order?
Yes, Deputy Collins.
That if the item is withdrawn rather than defeated on the floor of the Assembly, means it can be brought back more quickly, so not having to wait the minimum 6 months?
No. I stand corrected. It can be relodged after the Assembly, notwithstanding that it is within a 6-month period. There is a further standing order I would draw members' attention to, and that is Standing Order 83, that concerns references back. And that cannot be invoked because paragraph 2 of that standing order prevents the presiding officer from allowing a proposed reference back if the effect of that were to prevent the debate on the proposition resuming at a future meeting. Obviously, that's a future meeting of the term of this Assembly. That cannot happen, so that standing order cannot be invoked. So I hope that is useful to members. And with that reminder, we can resume the debate on the third amendment to the draft Animal Welfare Law. Does any member wish to speak on the third amendment? Deputy Coles.
Thank you, sir. I really rise just to make some clarifications that were slightly different from what the Minister said in his opening speech to these amendments, sir. The Minister commented that we were doing amendments to Article 34 of the law, which, as the Minister did correctly point out in his speech, that this deals with things like animals who are being imported with dock tails and cropped ears, things that the law doesn't allow to actually take effect in Jersey, and grant permissions to people to have animals with, I'll use the term mutilations because it's probably the easiest way to describe them, but sometimes they were done for medical purposes. But actually, so we're not really changing anything so as member of the Environment, Housing and Infrastructure Scrutiny Panel, the panel isn't actually changing these articles in any way. The only amendment to Article 34 that we're bringing is what enables our changes, which are actually to Article 18 of the law, which is, specifies about animal welfare related activities. So this is, as Deputy Curtis mentioned in his speech and Deputy Jen in her opening speech, this is where we believe as a panel that the Assembly should have the right to decide what activities, what forms of employment, what forms of animal husbandry ownership should be requiring a licence, because where at one point we may have what we may seem as a sensible minister, maybe that's the term I'll use, that they won't over-prescribe regulations by order. We might have one who's actually a little bit more strict and harsh and, thinks everybody who has anything from a goldfish should need a licence. And this law, as drafted, would allow a minister of the time by order to require the Constable of St Saviour to have a licence for his goldfish. Now, that would be pushing the boat a bit too far, but of course, we are then also talking about whether licence activities are meeting a required standard or are absolutely necessary. I mean, I think many of us and most of the constables would probably agree that dog walkers should need a licence, but actually should the Assembly have some input on whether that's for walking one dog, 2 dogs or 20 dogs? Those are just the questions, sir, because that's what our amendment is actually trying to instil. So I do urge members to support us. You might have your own opinions around the improvement notices because there's benefits and there are differences. Personally, I believe that, as the Minister has said continuously through our hearings with him and the regulation team, that his team generally goes by the 4 E's of regulation, which is to engage, educate. I can never remember all 4 of them. Maybe the Minister will remind me afterwards. But it gets to education, engagement and enforcement is the last option. So I don't think the need for improvement notices is required because that's the mantra that they use in their regulation anyway. So they'll engage with livestock owners, make sure that they fix the problems, and if it keeps on happening, then they'll get to the point where they will enforce. And the law still allows them that enforcement power, sir. So sir, I do hope members of this Assembly will support us and our amendments to this law, because I think this law is very much needed for updating, and these will make it more usable and practical law going forward.
Thank you, Deputy Coles. Deputy Jean, you indicated you had a question for the Attorney-General.
Yes, sir, thank you. In fact, I have 2. I'd just like, and it was focusing on some of the comments that the Minister made. Could the AG clarify if, under Article 17, if livestock keepers would be criminally liable for fencing, even if the fencing was not their responsibility?
Criminal liability for fencing for livestock owners. Attorney-General, do you want some time to consider?
I'm happy to venture an answer now. It is an offence, or it's proposed to be an offence under Article 12(7) that a person who fails to comply with an improvement notice commits an offence. Article 17, improvement notices, provides that the improvement notice, if the veterinary inspector confirms to an inspector that livestock is at risk or suffering or being injured as a result of straying into a public place because of the condition of the boundaries of the premises on which the livestock is kept, the inspector may serve an improvement notice under Article 12 on the person responsible for the livestock. not on the person responsible for the boundaries. They may be the same person, they may not be. My view as a prosecutor is that if I were asked to look at an infraction of an improvement notice in these circumstances, I would first, I think, want to have regard to the terms of any lease or licence under which the person responsible for the livestock was occupying the land. If it were genuinely the case that a tenant farmer had no control whatsoever in practice over his boundaries, well, that's a matter that I might want to consider as part of the public interest test and as to whether a prosecution met the public interest or not. It might, in the event of a prosecution and conviction, be relevant to mitigation of sentence. I hope that's helpful.
Deputy Journey, you indicated you have a second question.
Yes, sir, and it's related to, just to clarify the effect of our amendment for Article 18, requiring that the regulations for specific activities relating to animal welfare must be not be carried without without a licence, and this licence must be brought in by regulation. I would just, for clarification, what the effect of that would be for the minister to be able to bring in by orders, for example, around penalties, because I believe the minister was saying that wouldn't be possible, it'd have to come under regulations. But could the minister, for example, under orders, with our amendment, the Scrutiny's amendment, would the minister by order still be able to go into details about what that licensing scheme would be, including penalties, for example?
Mr. Attorney.
The penalties are already provided for in the draft law. The minister wouldn't, I think, need to go into penalties, therefore, by making orders, because a breach of the condition of a licence would be an offence under the law as it's presently proposed. But the effect I take to be of the amendment is this, and I don't know if members have it open, but Article 18, paragraph 1, the effect of that is that it would be for the Assembly, by regulation, to specify those types of activity which needed to be licensed. It would then be for the minister in paragraph 3 to provide the detail by order of what that licensing scheme would look like. And those details would include a list of things, not exhaustive, I think, because the word including is used, but down at 3B, including the conditions of the licence. So if we then turn to the law as proposed at Article 31.3, we see some offences and penalties provisions. Article 31, paragraph 3 provides that a person is guilty of an offence and liable to imprisonment for 2 years and to a fine if the person knowingly or recklessly contravenes any requirement of an order made under this law, including the terms of any notice, licence or other requirement imposed under it. And that, I think, reads back directly to Article 18, 3B as proposed to be amended by the panel. So the effect would be that the offence provisions would still pertain to licences made pursuant to order. That's how I read it.
Thank you, Mr. Attorney. Constable St Saviour.
Thank you, sir. Another one for the Attorney General, sir. Apologies if I've missed it. I can't find the page now. It's reference to technical mutilation of animals. There's a company locally who imports dogs, namely from Spain and other countries, that have had tails docked, which obviously would count as a mutilation. Wouldn't be importation of such animals would not be covered by regulations or not? Had a little dog from the Little Berts, my best friend for 13 years. Lovely dog, but as I said, the Spanish people did have a habit of docking tails. Thank you.
Mr. Attorney.
No, the prohibited procedure at Article 6 applies to procedures carried out within our jurisdiction. This law in itself doesn't prohibit the importation of such animals. Whether there is another law on the statute book which may, I would have to look, but I don't immediately know the answer to that. There we are.
Does any other member wish to speak on the third amendment? Constable Greville.
Thank you, sir. I'm a little bit anxious about the criminalisation of livestock owners. Just giving you two practical examples of incidences that I've been made aware of livestock becoming free of their boundary. Three sheep in particular, very well known to the conservation shepherd, who goes all over the island chasing after three sheep he calls Harry Houdini 1 to 3, sir, who are regularly going through any fence that he puts in their way. And in fact, I've met these three sheep on top of a bank below Bullivo football pitch. They'd escaped through their fence, as always, and were heading towards the football pitch, which was lush and green and looked very tasty to these sheep. I'm not making light of when livestock gets out, sir, because if those sheep had come into contact with a cyclist, for example, those sheep would have been severely injured, let alone what would have happened to the rider. But I would say that I've also come into contact with two heifers that came into my yard when I was playing football. Two heifers that had escaped from Trinity Manor, sir, and had gone through every hedge and fence for probably 3 miles and arrived in my yard, and we had to wrestle them to the floor because they were very frisky, to say the least. Those heifers would have damaged any vehicle they'd have come into contact with. So criminalising anybody that has livestock anywhere in the island, to me, I have a problem with, because those heifers literally had gone through everything in their way. Thank you, sir.
Thank you, Constable. Deputy Howe.
Thank you, sir. And like the Constable of Grooville, my husband has been in the Honorary Police in Trinity for about 11 years, and their major things are animals that have got out. Horses who've eaten other people's trees, cows that are all over the road, and sheep that we've had to find. They've gone from quite on top of Trinity all the way down to a field, and that's been quite a thing, and horses. And I do think we shouldn't be criminalising people for this. All they need, although the Honourable Police have had a bit of a job, when the farmer came with his bucket and his oats, or his nuts, they've got them in very quickly. But I just think we have to be quite mindful of what these are laws. I don't think we should be imposing laws on people for something that is dealt with in our the local parishes. And I also worry about having to have a licence for a guinea pig or a stick insect. Thank you, sir.
Thank you, Deputy Howe. Deputy Gorst.
Thank you, sir. I'm going to try not to regale members with escaped animals, but that, of course, is part of living in the countryside. It can't be helped. Animals are natural creatures, and we, as humans, fence them in. The point I wanted to make was I heard the mover of the proposition in her opening comments, and I thought to myself, why on earth are we not supporting the amendment from scrutiny? Why on earth are we not? And I leaned across, and I hope I didn't breach standing orders, and spoke to the Minister. And it became quite clear why we're not supporting it. Because of the reasons, if it were just simply by removing 17, all of these problems went away, then of course we'd be supporting it. The problem is, all that article does is remove at any point the requirement for a vet to agree with what the inspector has said. So by taking away Article 17, we're making it even worse, because with the greatest of respect to the Minister and his department and his officials, I would rather have a veterinary oversight and have that second defence whereby before they can be issued a warning or put in a way started on a criminal process, a vet has to come along and say, well, there was some harm to the life of that animal. Because I believe, sir, in the amusing illustrations that Constable of Grooville gave us, at no point actually was there a threat to the livelihood of those animals, other than the fact that they might have walked down a road. But I think that a vet would be very practical and would act as a stay upon an over-enthusiastic or over-officious inspector. And that's why I can't support the amendment, because actually it makes it more likely that someone may be criminalised if their animal got loose. And I, like the mover of the proposition, don't want to see that. This amendment doesn't decriminalise any actions. It simply says you're taking away the backstop of having a vet that say it's life-threatening to the animal. Without that backstop, it is simply in the hands of an inspector, and I can't accept that. I'd be cautious. I'm cautious about the whole thing because we're adding additional legislation, but I'm even more unhappy with the removal of that backstop. Thank you, sir.
Sir, would the Minister give way for a point of clarification?
Minister.
As in the Minister for External Relations or the Deputy?
Sorry, the Speaker. Of course I will, yes.
Thank you. It's just the Minister said, or the Deputy said, he can't support this amendment. Could he just clarify his case in his speech only related to Article 17? And the Deputy did highlight, the Chair of the panel, that this is taken in two parts. Could he clarify when he stated that he can't support this amendment, given this is broken into two votes, whether that objection relates to both parts or only the parts he actually spoke about and gave substantive reasons?
I'm not sure that really is a point of clarification, sir, but of course I spoke about the part of the amendment that I spoke about.
Thank you. Deputy Renouf.
Yes, I wonder if I could ask the AG a question before I start. And the Deputy Gorst raised this question around the application of Article 17, I think it is. Is it the case, could the Attorney General opine on whether the interpretation that was placed upon the effect of the amendment in relation to that is as Deputy Gorst said?
I'm going to apologise because I was busy dealing with another email and wasn't focusing as I perhaps should have done otherwise on what the Deputy was saying.
Well, the Deputy Gorst considered that the effect of Article 17 improvement notices is to make it more difficult for an improvement notice to be issued because of the requirement to obtain first confirmation from a veterinary inspector.
Very well, I'm grateful, sir.
Sir, the Attorney General really doesn't need to apologise for not listening to my speech.
Mr. Attorney.
Yes, well, that is the effect of it. I'm just trying to find the other passage for improvement notices. Yes, if one looks at Article 12, for just general improvement notices, it is an inspector who reasonably believes, and that's the trigger mechanism for an improvement notice under 12. But the improvement notice under 17 in respect of enforcement action for boundaries first requires the veterinary inspector to confirm to an inspector. So, as it were, it's the next man up the chain, woman up the chain, who is making the decision and passing it down. So there's that extra level of protection.
So the effect of removing that...
Through the chair.
Sorry, I beg your pardon, sir. So if I could clarify, the effect of removing that through the amendment would be to make it actually potentially simpler, but without the involvement of a vet.
Mr. Attorney, do you want time to consider that?
No, it does have the effect that Deputy Gorst is suggesting it has, because it is conceivable under Article 12 that an inspector alone could issue an improvement notice in respect of defective boundaries, because the inspector is able to take steps, any steps described in Article 11.1 as improvement. And 11.1 provides that it's steps that are a failure to take reasonable steps in the circumstances to ensure that the needs of animals are met to the extent required by good practice. In my view, ensuring that livestock is properly fenced, it is inevitably a step that is required by good practice to ensure the animal's welfare. So it is an extra protection in practice.
Deputy Alex Coles, you also have a question for the Attorney General.
Thank you, Deputy Alex Curtis. I know Deputy Coles and I look quite alike, but it was for the AG. On the back of that, it's just to understand the technical implementation, so that if improvement notices sit both within 17 and 11 or 12, is there still the vires to use those earlier articles, even though Article 17 exists? So the effect being described originally was if we remove the improvement notice under Article 17, it's easier because one can use, I think, Article 11. It is the effect that if we retain Article 17, an improvement notice cannot be issued under Article 11, a general improvement notice, or actually do the powers still sit to issue regardless under 11 or 17? So notwithstanding, one might go up the chain, as it were. There's no need to. There are multiple articles in which the law would allow the issuing of improvement notices nonetheless.
Mr. Attorney.
I think the better view is that where the law expressly provides for a more rigorous mechanism, then there is the expectation that the more vigorous mechanism will be used. And I don't think one could properly circumvent the requirements of Article 17 by saying, well, we can do it under Article 12 and it doesn't matter.
I thank the AG.
Deputy Renniff, you have indicated you wish to speak as well.
Yes, sir. I'm not sure. I hope I'm not the only person whose head is slightly spinning in trying to follow all of that. But the central point I want to make is that it seems to me, following all the AG's interpretations, that I still can't quite understand what the Minister is really concerned about with the amendment. The scrutiny amendments are about, first of all, limiting the Minister's discretionary power. He has to come back for the issues around licensing. He would have to come back to the Assembly to say more and make a case about why he wanted to license certain things, because he'd have to do it through regulations and not orders. And that seems to me that is a sensible thing for scrutiny to be saying. The ability to have such wide-ranging powers through order does feel like a danger of overreach, and I think I can't see the huge harm in bringing those powers back under the control of the Assembly through regulation. And I still feel that the central case that the scrutiny panel have made about the potential criminalisation of livestock owners for issues which are beyond their control is a step too far. And we've heard multiple, we've seen from the scrutiny panel report, multiple organisations are concerned about it. And again, it feels like overreach. It feels like the ends of the ends that the Minister is seeking to achieve can still be achieved reasonably and proportionately without the need for that power. It just goes one step too far. And so for those reasons, sir, I think I shall be supporting the scrutiny amendment.
Thank you, Deputy. Deputy Scott.
Thank you, sir. I think when I've looked at the scrutiny amendment, there are two issues that I think I've been thinking about, and one is the safeguarding of animals, and the other is safeguarding of democracy. And so I do have some sympathy for the, I think it's parts one, the parts that don't relate to Article 17 in terms of concerns about orders being brought in that could actually introduce whole regulatory frameworks, bearing in mind that if in fact the same departments are collecting the money for the licenses and things, that could be a potential conflict that needs to be prevented. Where I have a little bit more difficulty is in terms of this proposed deletion of Article 17. And I think it's quite important, and I know that people have been attempting to do that, other members have been attempting to do that, to just go back to the powers of an inspector themselves, because they are to ensure that they come in if they regard a person as failing to take reasonable steps in the circumstances to ensure that the needs of the animal are met. And then it says, to the extent required by good practice. So they are considering what is good practice. And then you have this additional provision, and it doesn't give the vet the power. It just says, if a veterinary inspector confirms to an inspector that livestock is at risk of suffering or being injured as a result of straying into a public place, because of the condition of the boundaries of the premises on the livestock is kept, the inspector may serve an improvement notice under Article 12 on the person responsible for livestock. So it doesn't actually change this whole assessment of good practice that has to be done by the inspector. So the reason why I balk at deleting this particular provision or actually supporting its deletion is I have a statement here. If a veterinary inspector confirms to inspector that livestock is at risk of suffering or being injured as a result of straying into a public place. So a vet is actually being given, is raising a concern. So, and why should they not raise that concern? Because what that leads to is an inspector actually thinking, well, nevertheless, what's good practice here? I don't think it really changes that assessment. So I'm happy to listen to more in the way of a response to that. But, it is when I'm actually, as a States member, I'm actually voting against something that seems to be intending to address a concern that animals may suffer or be at risk of injury, I find myself a little uncomfortable with doing that. So I do await to hear a bit more. Thank you.
Thank you, Deputy. Does any other member wish to speak on the third amendment? If no other member wishes to speak on the third amendment, then I call upon the chair to reply.
Thank you, sir, and I'll try to unpick maybe a little bit of what has been going on. First of all, I would like to hope the members can take comfort in that the scrutiny panel has reviewed the entire law in a scrutiny review. We specifically set up a scrutiny review for the animal welfare law and control review, which obviously is the dogs law amendment that we're bringing next. So we looked at this law in the round, and we really did scrutinise it fully. And so it is disappointing that the minister mentions that he felt that we were looking at these articles on their own and not in the round, because we very much were looking at this in the whole, and also, of course, working with the Law Officers Department to ensure that any amendments that we were bringing, whether deletion or amendment, fitted within the law. Specifically focusing on livestock straying. As has been said, it has been going back and forth. What we're concerned is that the onus is on the livestock keeper, even if the boundary fences are not their responsibility. And this is something that livestock keepers have contacted the scrutiny panel about, and that they were very concerned. They were also concerned about whether a veterinary inspector has the vires to be able and the knowledge to know how if a fence is erected in a way to keep in the animals or not. I think it's really important because, of course, the veterinary inspector and Articles 11 and 12 give that responsibility to the veterinary inspector, and the whole law, in fact, can give that confirmation if there is a risk of suffering and being and injured to the animals. And this talks to Deputy Scott's point. But the point of Article 17 is not about bringing up that suffering and being injured as a result. It's about the veterinary inspector looking at the conditions of the boundaries of the premise and saying whether the livestock is going to be able to be kept in or not. And that is, livestock keepers raised their concern that how would a veterinary inspector know and have that final responsibility to know whether a particular fence is put in a right way or not to ensure to hold livestock together. We also looked at it from the bureaucracy. You know, this feels very top down, it feels very heavy, and as we've heard from many people, we all have experiences of coming across straying livestock in Jersey. It means that it does happen. Hopefully with modern fencing, it's not as much as when we were younger maybe, but when it does that mean every time a veterinary inspector will have to be called out at the expense of government to then issue an improvement notice? You know, it feels very top heavy when we have the vires within Articles 11 and 12 to ensure that, going back to the risk of suffering and being injured for the animals, of course that's really important, and the scrutiny panel is very much aware of this, but we are not taking away those powers in the law for any inspectors to be able to make that judgment call. What we are concerned about is that extra layer of bureaucracy, the criminalisation of livestock keepers specifically, and about the understanding of fencing and who has that final power in deciding whether a fence can keep in livestock or not. And the Minister talked about our amendments being inconsistent, unclear and unworkable. But we're exactly saying the opposite. We think our amendments, especially to Article 18, ensures that there is clarity, because we're saying that any new licensing scheme must be created by regulations and not by ministerial order, so that there's no ambiguity, so that the states can work together, this assembly can work together to understand and give support to the Minister. And Deputy Curtis, Alex Curtis, mentioned this before, giving the support to the Minister to be able to go ahead and develop that licensing scheme. But as we heard from the Attorney General, the Minister then will have the powers under that by order to be able to develop the scheme specifically, and how they would want to, whether it's how to apply for the licence, how to vary the licence, how to suspend a licence, or deal with the costs and the fees around the licence. And I must push that the Minister talked about penalties, but as we again heard from the Attorney General, penalties are already in the law under Article 31. We are not taking away penalties or introducing new penalties. All we are saying is that we believe that, based on the conclusions of our review, is that activities around livelihoods, businesses, private animal keepers need to be ensured that comes through as regulation, that the Assembly as a whole believes that should happen before we give then the Minister to go ahead and the discretion to develop anything more by order. And at the moment we feel that this, as it stands in Article 18, not Article 34 as the Minister talked about, because that is not what we're asking. We're specifically talking about amendments to Article 18, that we feel that that we need to, any new licensing scheme should come back to the Assembly, and for the Assembly to give the go-ahead for the Minister to do that. We believe that that is democratic oversight. It gives us scrutiny. It gives us ability to discuss with those stakeholders that could be affected, to understand any unintended consequences. So with that, I would hope that members would be able to support our amendment. I will be taking it in two parts, as I indicated before, and hope that members will support the panel.
So which part would you like to take first?
We could take the Article 17, deletion of Article 17, which I believe is part 3. I have to go back all the way.
It's part 2.
Part 2, there you go. Didn't have to go all the way back to the beginning.
So you
of my
wish
speech.
part 2 to be taken separately from the other parts?
Yes, please, sir.
Would you call for the appel?
So can I just confirm, part 2 is whether or not we delete Article 17?
Delete Article 17, yes.
Sir, please.
Sorry, Deputy Scott.
What specifically are we voting on, part 2 now, or the...
We're voting on part 2 now, which is the deletion of Article 17.
Thank you.
So if members have had the opportunity of returning to their seats, I ask the greffier to open the voting in relation to part 2 of the Third Amendment. So if all members have had the opportunity of casting their votes, I ask the greffier to close the voting. The vote in relation to deletion of Article 17 has been narrowly defeated. 23 votes pour, 24 votes contre.
Those voting pour, the Connétables of St Lawrence, St Clement, Grouville and St Saviour, and deputies Labby, Doublé, Gardner, Balash, Coles, Wall, Miles, Renouf, Catherine Curtis, Rose Binet, Jeanne, Howell, Kovac, Alex Curtis, Wilson, Stevenson, Andrews, and online deputies Moore and Porre. And those voting contre, the Connétables of St Helier, St Brelard, Trinity, St Peter's, St Martin, St John, and St Juan, and deputies Southern, Tadier, Luce, Morel, Lehegara, Ayer, Rob Ward, Alves, Gorst, Farnham, Mezek, Scott, Feltham, Miller, Tom Binet, Ferry, and Barbara Ward.
Thank you. Then we move on to the second part of the vote. So that is in relation to parts 1, 3, and 4 of the Third Amendment. And if members have returned to their seats, I will ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. Again, the second part of the vote has been narrowly defeated. 23 votes pour, 24 votes contre. In that case, we move to the Minister's Second Amendment. Minister, do you wish to propose the Second Amendment? Sorry, greffier, would you please read the Second Amendment?
Article 34. In Article 34A, in paragraph 2, for 1B, substitute 1C. B, after paragraph 4, insert 5. Before making an order under this article, the Minister must inform each scrutiny panel established under standing orders to which is assigned scrutiny of matters relating to animal welfare legislation.
Minister.
Thank you, sir. There was a time I wondered if I would get to propose this, but I will do. Some members may have looked at this amendment and thought it was worthy of some support and consequently voted in the last two amendments as they did. Firstly, sir, I just want to amend a typo substituting B by C in the Article 34, paragraph 2 to ensure that all the cross-references are correct. I just want to go on to say that following discussions with the panel, I'm proposing to provide the panel with more assurance and a mechanism to ensure overview of orders made under the Animal Welfare Law. To that effect, I propose the addition in Article 34 of paragraph 5 to make it a legal requirement for the Minister of the Day to inform the scrutiny panel before making orders under the law. I trust this will give security to scrutiny and the assurances that they need. This amendment may allow scrutiny to examine any planned orders and prevent the Minister of the Day from making significant changes without any checks and balances ensuring oversight. I trust this is a pragmatic way to ensure oversight without any major changes to the law and avoiding unintended consequences of a more significant amendment. It allows for better oversight, as I said, without compromising animal welfare, and it allows the Minister to respond quickly when required and when animal welfare is at risk. I'd like to think, sir, that my approach strikes a balance between accountability and practical flexibility and promotes the ongoing collaboration between Scrutiny and myself, which we've done, and I know Scrutiny is a critical friend. They've been critical in this last debate, but we've come to a conclusion. So I'm grateful for their criticism and their collaboration, and we do work together on this. For members' information, Article 34, I'm going to make a substitution, Article B, 34, paragraph 3, insert. Before making an order under this article, the Minister must inform each scrutiny panel established under standing orders to which is assigned scrutiny of matters relating to animal welfare legislation. That's my proposal, sir, and I very much hope that members will support it. Thank you.
Thank you, Minister. Is the second amendment seconded? Does anyone member wish to speak on the second amendment? Deputy Jean.
Thank you, sir. And while I welcome that the Minister has responded to concerns raised through the panel's animal welfare and control review, I must be clear that the panel believes that this amendment does not solve the issue at heart. The proposal before us suggests that scrutiny panels are simply informed before an order is made, but awareness is not the same as oversight. Being told after a decision is effectively made does not give scrutiny any meaningful opportunity to challenge, shape or influence that decision, especially in public. And at the heart of this is a much bigger concern as we still push, though we've talked about it already through our amendment that was narrowly defeated by one, the law would still allow a minister by order to introduce new licensing schemes for a wide range of animal-related activities, potentially extending well beyond current policy intentions, and this would then mean that though the scrutiny panel would be told about it could be told there is no time limit on this. So it means we could be told a few minutes before lodging, for example. We do not know when that this will be told, but if we're being told a couple of weeks before, what is the varies within this to help scrutiny to be able to talk to the minister and be able to give input to these orders? That is not listed in this at all. It does not give any of that accountability and oversight and public scrutiny that that we would desire if instead a regulation would come to us, but rather an order, because an order can be very quietly put into the domain at the last minute, and as they scrutiny only told, and we've had that, I'm afraid, on a number of occasions where we have only received maybe a few hours before it going live, specific information about an order. So we do not believe that this removes any flexibility for the minister, and it just ensures that a decision, I think it's, though I understand, and maybe many members will see this as an olive branch from the minister, and especially in regards to our close defeat last time, I think for us as scrutiny, we looked at this amendment and we felt that still we don't want to become part of something that we could be complicit on, and we would be seen by the public to be part of that information, receiving that information, not being able to question in public about that information, because that information is not being put in the public until the order has actually been lodged, and we feel that that limits scrutiny and ties scrutiny's hands behind their back to be able to do the oversight and the accountability work that we need to do, and so for that reason we don't agree with. I don't agree with this amendment. The panel doesn't agree, and we would ask members to reject the amendment.
Thank you, Chair. Deputy Scott.
Thank you, sir. I sympathise with the chair of the scrutiny panel that this seems a poor second best to her and the panel, but I do wish to point out that it nevertheless is better than the situation that we already have. When I was a chair of a scrutiny panel, as we all do, we do get copies of orders when they've been made, and I believe under law there is a 2-week period, although I may have to check that with the Attorney General, where the States Assembly could actually resolve to have them reversed. Perhaps I shall ask the Attorney General to check that.
So, Mr. Attorney, you're being asked whether there is provision under the law where if an order is lodged as passed by a minister or as issued by a minister, is there the ability for the States Assembly to ask for a debate in relation to that order, and if so, within what time period?
I was rather hoping that others might know the time frame understanding orders, but the effect of lodging an order is that any member can lodge a proposition to debate that order with a view to having it annulled. I think that's the legislation law. I'd have to turn it up to be doubly sure, but I'm confident that is the legal procedure. I'm not sure I know the time frame.
Thank you. So unlike ministerial decisions, and in this respect, I have had difficulty with some of the provisions in the planning law where the minister can make decisions, they just cannot be annulled in this way. Orders, at least, there is a period whereby the States Assembly can choose to annul them. So this amendment allows the scrutiny panel just a little bit more of a highlight that such an order is being made, and just a bit more time, therefore, to consider exercising these rights. So I will support this amendment.
Thank you, Deputy Scott. Deputy Alex Curtis.
Thank you. I'll be brief, and the AG might assist us. I believe it's Article 11 of the legislation law, and subordinate legislation may be annulled no later than 3 sittings. But I mean, that's by the by. As the Chair says, I think this objectively makes the law worse. I think bringing in a notification to scrutiny without any statutory power to call it in, any mechanism of recall, is not a good way of performing that. I'm not aware of any other order-making power that has such a informing provision, and I don't think it's something we should adopt in our legislative formatting. Therefore, whilst it is well-intentioned, clearly those who are currently the active scrutiny members do not want this, do not think it's the right mechanism, and actually I do believe the law would be better to follow standard drafting, the Minister may by order, and obviously if they do not inform, if they are not consultative, then they're probably not working well with scrutiny. But this is not commonplace and should be rejected outright.
Thank you. Deputy Balash.
So I agree with Deputy Curtis and with the chair of the scrutiny panel. We have an established constitutional procedure in relation to regulations and orders. We require matters to come before the states and be enacted by regulation if they are matters where the principle requires that the Assembly should take a view on the matter. And an order is a technical minor matter which everyone is satisfied can be delegated to the Minister to decide. This is a sort of hybrid which I think we have never enacted before, and I think it's an extremely bad precedent for all the reasons given by the chair of the panel. The trouble with enacting provisions like this is that the legislative drafter will tend to follow them. If the minister, any minister in future, thinks that he doesn't really want to be bothered with a regulation making power by the states, but he thinks he might not be able to get away with making a provision for an order-making power. And this is a kind of hybrid which can be slipped in to satisfy members of the states who think that there should be a regulation-making power. All that it demonstrates, to my mind, is that the Minister should really have accepted the amendment of the scrutiny panel, which was so narrowly defeated. It is a shame that
we failed to adopt that course. But this, I think, is wholly undesirable for all the reasons that others and I perhaps have given, and I'm going to vote against it.
Thank you, Deputy. Does any other member wish to speak on the second amendment? If no other member wishes to speak on the second amendment, I call upon the Minister to reply.
So can I start with a question? Am I at liberty to withdraw this amendment at this point if I wish to do so?
Minister, you'll need the leave of the Assembly to do that.
Can I propose, can I ask the Assembly whether they would give me leave to withdraw the amendment?
So the proposition is to withdraw this amendment. Is that seconded? Is there anything you wish to say in relation to the proposition, Minister?
I think there's very little to say. I can only agree with Deputy Ballas, Deputy Curtis. I did this in order to try to make it easier for scrutiny and myself. I'm going to find myself arguing for scrutiny, while scrutiny arguing. It'll get really complicated. I think I'm happier to withdraw.
Does any member wish to speak on the proposition to withdraw this amendment? If no other member wishes to speak, would members kindly show? The proposition is to withdraw the amendment. The proposition is adopted and the second amendment is withdrawn. So in that case, we return to the articles. Does any member wish to speak on the articles? Deputy Alex Curtis.
Thank you. Very briefly, sir, many of the points around some of the main topics have been made. I would like to highlight, though, that as drafted, straying livestock is part 4, Articles 14 through 17. There's been cause for concern as to whether straying livestock should be an offence outright. And I would say, from my personal view, the scrutiny panel heard that actually, whilst livestock stray, the current methods of making sure livestock are safe and addressed work. The Honorary Police basically said, and I don't wish to paraphrase, but we know how to handle it. This is something that Jersey's done. So members may wish to take a personal decision on whether we include Part 4 straying livestock at all. And so I'm just giving notice in this part of the speech that I would like Articles 14 through 17 voted on separately.
Deputy Jeune.
Thank you, sir. And I rise as the chair of the scrutiny panel just to highlight briefly summarise the findings of our review, which we took when we called in this after the principles. And as I said during the principles debate, the panel is in broad support of this intent of this legislation. There is broad agreement that Jersey's existing framework is out of date, that the reform is necessary to improve animal welfare, strengthen enforcement, and move towards a more preventative system rather than one that reacts after harm has occurred. And we heard consistent evidence that there are gaps in the current law, times limited the abilities of the agencies to intervene early with animals effectively falling through the cracks. And that can't continue. However, our review also identified a number of significant concerns, and when legislation affects everyday life, such as farmers managing livestock, dog walkers, groomers, inspectors responding to welfare concerns, it must be clear, proportionate and workable in practice. And it also must be accountable. And so we identified as a panel a number of issues that we are looking forward to the Minister to be responding to the review as soon as possible. First, there was a short consultation period for legislation of this scale, which limited the ability for stakeholders to fully engage. Stakeholders from farmers to charities told us that parts of the draft law were still unclear and that insufficient consultation had led to uncertainty about some of the provisions and how they would operate in practice. Second, there was a lack of clarity, particularly around shared responsibility for animals, an issue that arises frequently in real-life situations from temporary care of an animal to professional services. And thirdly, confusion across enforcement agencies we heard clearly, and we had a specific hearing where we had the states, Jersey Police and the honorees, the chef d'honoré, come to talk to us specifically on the animal welfare review. And we heard clearly that unclear roles and responsibilities are leading to misdirected calls, inconsistent responses, and unnecessary pressures on policing resources. And this is not just an operation issue, it affects public confidence in the system. We heard that some existing offences are difficult to enforce in reality, with low prosecution rates and a high evidential threshold. And that raises questions about whether the new framework will generally improve outcomes and that is both clear and workable. Of course, we have gone through the panel came across two of the concerns, which of course we've already tackled through our amendments, and I fully support Deputy Alex Curtis in taking the livestock straying as a separate vote. But reform must ensure clear agency roles, accessible public guidance and proportional provisions, particularly for livestock, and appropriate assembly scrutiny where significant regulatory change is proposed, especially because this will impact local businesses and individuals. And encouragingly, we did see strong support for the preventative approach. And so we really hope that all those agencies that we have identified and talked to and stakeholders that have contacted us can work together to work on better awareness and education, so there is clear understanding from the public about what roles and responsibilities are across agencies. And because this law could make that real difference, but unless people understand it, it will be really difficult to implement, or there could be the unintended consequences of a lack of trust and misunderstanding in how the law is actually implemented, which could have detrimental effect for animals as well as for those who are in the animal businesses and looking after animals. Because and it's something we will talk about under the dogs law. There is fragmentation across Jersey's animal control framework. There is multiple laws, inconsistent rules, unclear definitions, and poor signposting or understanding and guidance for islanders. And though this is subject for another debate, I think it's important that we recognise this within this review, within this law, and we highlighted it in our review because it does undermine compliance and it does undermine trust when there is little understanding in the public of what actually whose responsibilities are. And who they should report to, and where islanders should report to. So with that being said, I would really like to thank those who contributed to the review, enforcement agencies, farming representatives, animal welfare organisations, Committee de Connotabs, and members of the public, because their practical insight has directly shaped our recommendations and the amendments that have come before, and the panel looks forward to receiving a response from the Minister to our findings and recommendations and follow up to if this law is adopted.
Thank you, Deputy. Does any other member wish to speak on the articles? If no other member wishes to speak, then I call upon the Minister to reply.
Thank you, sir, and I'll try to be brief. Yes, of course, I will respond in the allotted time frame. I want to continue to work with scrutiny on this. We've had two sides of an argument here, but this is about shared responsibility between owners and keepers, and very clearly there is shared responsibility there, and if somebody's responsible for an animal, it may be on that particular day they're looking after them. I want to point out to the Assembly, when we talk about straying, it's not an offence, it's not a criminalised offence to stray. The offence is to not take notice when an inspector has told you to do better. So you could have animals in the field, you could fence them in, you're not committing any offence. An inspector turns up and says, that's not good enough, you must do better. If you fail to take notice and take action, that's when you start falling foul of the law. I just want to say, and that's where the needs of animals need to be taken into account versus, on the other hand, the inconvenience of the keepers. This law is about increasing animal welfare. That's why keepers need to take a little bit more responsibility. But I'll leave it there, sir. I accept that Deputy Curtis wants Part 4 taken separately, and that's fine by me. I'll take it in 3 sections, but I would say to the Assembly, if we don't adopt Part 4, the ability for veterinary officers, veterinary inspectors to act is removed, and all the responsibility will fall on 2 people. The first is the police, and the second is the honorary police, because they were the only ones who would have any inquiries. They won't be happy about that, but that's for another day. I just want to warn members, well, not warn, just to say, if we don't vote in favour of Part 4, the ability of my veterinary officers to act will be removed. But I'll leave it there, sir, and I accept we'll take, the first part would be, we'll take this in 3 sections. The first section would be parts 1 to 4, 2, 4.
1 to 3, isn't it?
1, 2 and 3.
1,
That's
2 and
simpler for me to say it that way. We'll take 1, 2 and 3 first, and I'd like to call for the appel, please, sir.
So the appel is called for. So the appel will, the first vote will be in relation to parts 1, 2 and 3 of the articles. So I invite members to return to their seats. If all members have now returned to their seats, I ask the greffier to open the voting in relation to parts 1, 2 and 3 of the articles. I ask the greffier to close the voting. Parts 1 to 3 have been adopted unanimously. 46 votes for, no votes contra, no abstentions. So, Minister, would you like to take part 4 of the articles?
If I could, please, sir.
And you call for the appel?
I do.
The appel is called for. I ask the greffier to... I ask the greffier to open the voting in relation to part 4 of the articles. It's articles 14 to 17. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. And part 4 has been adopted, 39 votes for and 6 votes contra. Minister, do you call for the appel in relation to parts 5, 6 and 7 of the articles?
I do, please, sir.
So the appel's been called for. I will ask the greffier to open the voting in relation to parts 5, 6 and 7 of the articles. All members have had the opportunity of casting their votes. I ask the greffier to close the voting. Parts 5, 6 and 7 of the articles have been adopted. 45 votes for, 2 votes contra and no abstentions.
Deputy Alex Curtis and Deputy Moore online.
So we move on to third reading. Minister, do you wish to propose the matter in third reading?
Sir.
Is the matter seconded? Does any member wish to speak in third reading? Minister?
Very briefly, sir, I'd just like to thank members for their input into this debate. Clearly, we've had some disagreements which we've sort of resolved, but I commit to continue to work with the scrutiny panel while I can. I will be responding to them. I'd just like to thank my officers in my department, sir, and law drafting officers. This is a major revamp of animal welfare in this island. As I said in my opening speech, the 2000 law that's being replaced today was based on legislation in the UK which went back to the early 1900s. So it's a major, major step forward for us. It puts us at a good equivalence with the UK and the EU, which stand us in good stead and shows us as a responsible jurisdiction when it comes to animal welfare. I commend it to the Assembly and hope for some support.
Thank you, Minister. Does any other member wish to speak in third reading? If no other member wishes to speak in third reading, Minister, do you wish to reply?
I call for the appel, please,
You
sir.
call for the appel. So the appel is called for, and if the greffier is ready, I ask the greffier to open the voting. If all members have had the chance of casting their votes, I ask the greffier to close the voting. And the law has been adopted. 46 votes pour, 1 vote contre, and no abstentions.
One, please.
Deputy Alex Curtis voted contre.
Very well, so we move on to the second item of public business, which is the draft Dogs Law Jersey Amendment Regulations, P43. Members will recall that the minimum lodging period was reduced this morning. The regulations are lodged by the Environment, Housing and Infrastructure Scrutiny Panel, and the main respondent is the Comité des Connétables. And I will ask the greffier to read the citation, please.
Draft Dogs Law Jersey Amendment Regulations 2000. The states make these regulations under Article 13C of the Dogs Jersey Law 1961.
So, Deputy Jeune.
Thank you, sir. This proposition comes from the work of the Environment, Housing, Infrastructure Scrutiny Panels during our Animal Welfare and Control Review, and it is before the Assembly for a simple reason that the current law does not work well enough to prevent livestock worrying. The issue was first brought to the panel's attention by a local farmer during the Dogs Law amendments that the Committee de Connétables brought late last year. That farmer raised concerns that the legislation did not properly address the very real problems faced by those who keep livestock on our island. When we began to explore the issue further, it became clear that this was not an isolated concern. The same message was repeated by a number of stakeholders that I believe some of the Assembly members have received letters of such an effect in the last few days. Messages from the Jersey Farmers Union, the Conservation Grazing Group, which also includes the Government Land Resources Management Team, the National Trust and the Jersey National Park, and even the New Era Veterinary Team. Managing conservation grazing sites run across over 40 sites in Jersey that include farmland, meadows, coastal and dunes and woodland. And there's about 500 sheep, delivering an estimated £500,000 of environmental value to the island each year. And they described a situation where livestock worrying, particularly involving sheep, is not only happening, but appears to be increasing. Dogs are being exercised off-lead in areas where livestock are grazing, and too often owners either do not realise the risk or underestimate the consequences. When a dog chases a sheep, it can cause injury, miscarriage in pregnant ewes, and in some cases the death of animals through stress or exhaustion. Even when there is no direct physical injury, the welfare impact can be significant. For farmers and those responsible for conservation grazing, the consequences are both financial and emotional. This is their livelihood as well as an animal welfare issue. Yet despite this, the evidence given to the panel was that the current law is extremely difficult to enforce. During our public hearing with the States of Jersey Police and the Committee de Chefs Police, we were told that investigations into livestock worrying are very difficult and prosecutions are rare. In practice, unless there is clear injury or death, enforcement agencies often have little option beyond offering advice. Members will appreciate why that is a problem. By the time harm has occurred, the damage has already been done to the animals, to the farmer, and to the wider rural community. It is clear that the vast majority of incidences, probably around 90%, are unintentional. So this amendment therefore introduces a preventative element into the law, just like the animal welfare law that we have just passed. A dog will be considered to be worrying livestock if it is off the lead. This amendment therefore introduces a preventative element. A dog will be considered to be worrying livestock if it is off lead or not within 5 metres of the person in charge on agricultural land where livestock is present. This does not create an unreasonable burden on dog owners. It simply establishes a clear expectation of close control where livestock is present. And members will be aware that dog ownership has increased significantly by around 25% in the last 5 years, which makes clarity in the law even more important. Members will also see that sensible exemptions are included for police dogs, for farmers on their own land, and for those authorised by the landowner or livestock owner. It is also important to emphasise that this amendment does not change existing permissions for dogs to be off-lead in public parks. Those arrangements remain. This provision only applies where livestock is present. The panel also conducted a children's rights impact assessment as part of bringing this amendment forward. The overall conclusion was that this amendment does not create new risks, but provides clearer expectations. It does not introduce a new form of liability for children. The Assisting Dogs Law from 1961 already applies to both the owner, which could be someone above the age of 16, and any person in charge of a dog, without defining a minimum age. That position remains unchanged. What this amendment does is modestly widen the circumstances in which the existing offence may apply. While the law technically allows for any person in charge of a dog to be liable, we were reassured by evidence that prosecution rates are very low and that issues are overwhelmingly dealt with through advice. This reinforces that the intention is education and prevention, not punishment. On the other hand, there are clear positive impacts. By setting a clearer and more objective expectation for dog control near livestock, the amendment supports better understanding of responsible behaviour, including among young people, and contributes to safer rural spaces. It also reduces the risk of children witnessing distressing incidences involving livestock and supports the well-being of farmer families whose livelihoods depend on those animals. In fact, by reducing the likelihood of incidences, this amendment supports safer shared use of the countryside, benefiting families, children, and our wider community. What this amendment does is give enforcement agencies a practical tool to act before harm occurs, rather than after it. It also brings Jersey more closely into line with provisions that already exist in the UK. Sir, the panel did not bring this amendment lightly. We recognise that responsible dog owners make up the vast majority of people who enjoy walking their dogs across the island. This amendment is not about penalising them. It is about closing a clear gap in the law identified by farmers, conservation groups and enforcement agencies alike. It is about protecting livestock and supporting those who manage our countryside. And it is about ensuring responsible dog ownership, including understanding the impact dogs can have on other animals. Education and awareness will be key, including clear, consistent signage where livestock are present. Members, I believe, and as a dog owner as well, I believe that this is proportionate and a preventative measure. It responds directly to the concerns raised and provides a clear, more enforceable framework. For those reasons, I do encourage members to support our amendment or our proposition.
Thank you, Chair. Are the principles seconded? Does any member wish to speak on the principles? Constable of St Brelard.
Thank you, sir. And I'm grateful for the panel bringing this amendment. And as the chair indicated, we have discussed this with the person responsible for the some 500 sheep in the island. And I'm also very sympathetic towards the situation he finds himself in and his team find themselves in that they are finding their sheep attacked by dogs unknown, and they're having to deal with these unfortunate animals who very often lose their lives as a result. It's not an easy, there isn't an easy answer, sir, and it is all about signage, education, escalation, and then enforcement. The police have difficulty very often in proving who might have, or who might the owners were, who own these dogs, who might have attacked the sheep. And I think this is a step in the right direction. It is a tool for the police to be able to deal with these situations where animals are being worried. Effectively, so it's one of those things where it'll be easy not to support, because have we got stakeholder engagements? And you might say stakeholders in this case are dog owners, and with several thousand dog owners on the island, I can't say that we have engaged with all of them and got their views. It's probably towards as clear and workable in practice as it can be. I think the offences, if created, will be quite difficult to enforce when it comes to parish hall inquiries or magistrate court decisions. So I think the focus will have to be on a preventative approach, awareness from the point of view of the general public, and a realisation of responsibilities of being a dog owner. So I've never liked supporting laws which are unpoliceable, but we've got a grey situation with worrying, where we have to give, as I alluded to earlier, some tools to the police to be able to do it. And I think this is the best way to do it. So I'm pleased to be able to support the amendment. Thank you, sir.
Thank you, Comitar. Does any other member wish to speak on the principles? No other member wishes to speak on the principles. I call upon the chair to reply. Dr. Jean.
Thank you, and I'll just be brief, and I thank the chef to the Conotabs for his words. I think this really is about a balance between the rural realities of rural livelihoods, and we are talking about businesses here, as well as those who are also doing conservation work for the government at a much lesser cost through the use of animals and the use of sheep than to use trying to use machinery, and that will be much more costly and also environmentally degradation as well. So I think that's important to make that balance, but also understanding that the dog owners need to have places in Jersey to exercise their dogs, to be with their dogs, as a dog owner, of course, and you're finding new places to walk with my dog. I think that as we identified in the review, and as I said under the animal welfare, there needs to be, and it's something that a recommendation and findings in our review is that this wider issue of control needs to be looked at in the whole. Though we see this as a particular amendment we felt that we could bring now at this stage, because it was a particular call from as somebody with a business and a livelihood is seeing a real impact of the increase in dog ownership and the increase of, unfortunately, some who are irresponsible when walking their dogs around their business and their livelihoods and animals, and for that matter, and the impact of that has on the animals' welfare themselves. We felt that this is what we could do now, but we do call for a more stronger review around all the different frameworks, because we had to look at a number of laws, roads law, the policing of parks and gardens laws, there was many elements, and it is confusing, and it is confusing for dog owners to understand their responsibilities, and so I do call upon the stakeholders, including the Conotabs, to be able to work to ensure that there is as much clear information for dog owners to understand where they cannot walk their dogs, whether at all, on the lead, off the lead, at different times of the year. It is difficult out there to navigate, and it would be really important to get that in. But for this particular amendment, we felt we could really make an important impact for local businesses who are seeing the impact of their livelihoods being affected by attacks from dogs. Thank you.
Thank you, Deputy Jean. The appell's called for.
Yes.
I ask members to return to their seats. If all members have had the opportunity of returning to their seats, I ask the greffier to open the voting. If all members have had the chance to cast their votes, I ask the greffier to close the voting. And the principles are adopted. 41 votes pour, 2 votes contre, no abstentions.
Those voting contre, Deputies Howell and Tom Binney.
It's registered that was a mistake, sir.
So very well, we move on to the debate on the regulations in second reading. How do you wish to propose the regulations in second reading, Chair?
On block, please. I don't
Do you wish to speak in relation to the regulations?
I believe I've said all that needs to be said and hope that members will support this second reading.
Does any member wish to speak on the regulations? If no member wishes to speak, I close the debate. I assume there will be no reply.
Call for the appel.
So you've called for the appel. In that case, I ask the greffier to open the voting. If all members have had the chance to cast their votes, I ask the greffier to close the voting, please. And the regulations have been adopted in second reading. 44 votes pour, no votes contre, and no abstentions. Do you wish to propose the matter in third reading, Chair?
Yes, please, sir.
Thank you. Is the matter seconded? Yes, sir. Does any member wish to speak in third reading? Deputy General.
Sorry, sir. I had a light on.
Deputy Alex Curtis.
Thank you. Just a quick one. I know others have said about businesses and obviously animals, but it is important to remember that this is about as much animal welfare and not the businesses who are husbanding those animals. And I think those who, all members were circulated comments by the Jersey Farmers Union in a letter to scrutiny in which they say this will be the biggest improvement to our farm animal welfare legislation in decades and will help us prevent many animal welfare issues before they occur. And so I think we should commend this as a good piece of animal welfare legislation.
Thank you very much, Deputy Curtis. Constable St Brellard.
St Brellard, I think.
St Brellard.
Thank you, sir. Really, my comment was just to refer to the letter received from the Children's Commissioner, which I couldn't quite understand the thrust of that point. And whilst one respects comments from the Commissioner, so I think she was possibly misguided in her view as to what this law was seeking to achieve. So I, in summary, am pleased to support the law in third reading.
Thank you, Constable. Does any other member wish to speak in third reading? Deputy Jean, do you wish to reply?
Yes, sir, and I thank Deputy Curtis for specifically highlighting those important words from the Jersey Farmers Union, and we did also circulate, and I would like to thank the National Trust, Jersey National Park, and also those particularly who are livestock keepers who have raised their concerns and the needs for this legislation and how important it is to going forward. And I think just reiterating that this needs to be looked at as part of a wider review on animal control, and that does need to be looked at in the round to make everybody and all islanders understand their roles and responsibilities, and so that it doesn't, by mistake, make people criminally liable for something that they didn't know about. So I think that is really important, and it's the responsibility of those who are within this and the stakeholders to make sure that it's all possible, make sure that dog owners really know that they are entering a site where livestock is. And maybe just to last minute with the information around the Commissioner for Children, it would be good in the future we could have more of a dialogue with the Commissioner to understand their concerns and be able to relay how we had done the amendments that were a tweak to a law that potentially needs to be looked at in that round related to what the Commissioner has related to, but it was something that the scrutiny panel, it was not in the advisories for the scrutiny panel. But we did issue a career, and we hope that members were able to take satisfaction from our career, that we looked at impact of children and we saw that there was a balance. We wanted to carry on with this amendment. So I'd like to just thank officers and those who have taken their time to support the panel in doing so as well. Thank you. I call for the panel.
Panel's called for. I invite members to return to their seats, and I ask the greffier to open the voting. If all members have now cast their votes, I ask the greffier to close the voting. And the regulations have been adopted in third reading unanimously, 45 votes for, no votes contra, and no abstentions. So we move on to the next item of public business, which is treating children as children, P14 of 2026, which has been lodged by Deputy Balash. The main respondent is the Minister for Education and Lifelong Learning. Two amendments have been lodged to the proposition, one by Deputy Balash and another by Deputy Gorst. Deputy Balash, do you wish to propose the proposition as amended by your own amendment?
So I wonder if I can propose my proposition unamended, because I think that if Deputy Gorst's amendment is adopted, my own amendment will fall, and therefore there's no need to debate it.
Very well. Deputy Balash, are you minded to adopt the amendment lodged by Deputy Gorst?
I would like to reserve my position on that, sir, because I would like to hear what Deputy Gorst has to say.
Very well. So we will deal with Deputy Gorst's proposition. So I ask the greffier to read Deputy Gorst's. I beg your pardon, we have to read the main proposition first. So I invite the greffier to read the main proposition.
The states are asked to decide whether they're of opinion to request the Minister for Education and Lifelong Learning to replace the existing trans inclusion guidance, non-statutory guidance for sites including schools and educational settings in Jersey, published on 17th of March 2025, with a document entitled Treating Children as Children, a Safeguarding Approach to Trans-Identifying Children and Adolescents in Jersey Schools, contained in Appendix 1 to the report accompanying this proposition, and to make this available to all schools and educational settings.
So, Deputy Balash.
So I appreciate that this is a sensitive subject upon which strong views are held, and I will express myself carefully. Since lodging this proposition, I have spoken to a great many people on both sides of the argument. Most importantly, perhaps, I met two gender-questioning young people, aged 12 and 14, at their request. And I want to say, because they may be listening, that their contributions were extremely helpful. It is clear, as was stated by Dr. Hilary Cass in her report in 2024, that there is a wide divergence of views as to how to deal with children and young people
who feel anxious about the biological state into which they were born. The evidence, as Dr. Cass said, is sparse, the dangers of transition not fully understood, and any benefits perhaps not fully appreciated either. A cautious approach seems sensible. Having said that, I fully respect the right of adults to change their gender and to choose who they want to be. They should be free to take decisions about their own bodies. But we should be clear that we are not debating trans adults or their rights. We are talking about children. As the proposed guidance states, children cannot accurately be described as trans. Young children are still learning to distinguish between reality and fantasy. That's why they can believe in Father Christmas. Adolescents are beginning to discover their sexuality and orientation. Their identity is fluid. Treating an adolescent as a trans person as if their identity were fixed is harmful because it may cement an impression which might otherwise have faded away. Children should be treated as children. That does not mean that their voices should not be heard. Of course they should be listened to. But listening to children doesn't mean that they should mandate what adults do. Having listened to the child, adults should take appropriate decisions, having regard to their duty to safeguard that child, and indeed all children. An adult cannot abrogate his or her duty to do the right thing for children by leaving it to the child to decide what the right thing is. That ought not to be controversial. The main issue today is what is the right thing for the adult, teachers in particular, to do when faced with a gender-questioning child. This debate is about safeguarding and not about equality and diversity. Treating children equally goes without saying. But safeguarding seems to mean different things to different people. What I mean by safeguarding is protecting the child so that he or she can grow up into an adult able to do all the things that adults do. Enjoy a fulfilling sexual relationship, have children maybe, and enjoy life to the full. None of those doors should be closed by decisions made while the child did not have sufficient maturity to understand the consequences of their actions. Sometimes that means not giving adult validation to a decision that the child wishes to make. I illustrate that point by telling members a true story of an attractive, rather petite girl who in 2021 was a 16-year-old student at a Jersey secondary school. She socially transitioned to become a boy, a decision which the school facilitated by using a new name, male pronouns, and treating her as if she were a boy, all as set out in the schedule to the existing guidance. She took cross-sex hormone tablets. Her voice dropped and she grew facial hair. After school, she went to university and there realized that she had made a terrible mistake. She detransitioned to live as a young woman, but must still cope with unwanted facial hair and other male attributes. She has, for the present, lost her good looks. I think that was a tragedy, facilitated by a breach of the school's duty of safeguarding, which was encouraged by the department's existing guidance. It is unsurprising, in my view, that more than 1,000 people signed the petition seeking to revoke the guidance. Members will have received an email from the Vice Chair of the governing body of Holia criticising the current guidance. His concern, he said, is grounded primarily in safeguarding. Inter alia, he wrote, and I quote, "The guidelines give insufficient weight to the findings of the UK CAS review, a 4-year independent research programme examining how best to support children identifying as trans. One of its key conclusions is that caution should be exercised when children seek to socially transition, rather than automatically adopting an affirmative approach. The existing guidance is not cautious about social transitioning. In fact, it endorses it. There are two possible approaches to the gender questioning child. They are the watchful waiting approach and the gender affirmative approach. The watchful waiting approach is essentially neutral. It allows the gender questioning child to express himself or herself. Adults can listen to the child, be kind, understanding, and empathetic. They should firmly squash any bullying of such a child, but they should not positively endorse or encourage what the child is saying. The watchful waiting approach was the norm until the emergence of the gender affirmative approach generated by a new ideology about 15 years ago. The Minister has said that he endorses the watchful waiting approach, and his comments paper says it too. Unfortunately, it's not what the existing guidance says. The gender affirmative approach involves the adult in the affirmation of the child's belief that he or she is of a different gender. That affirmation can take the form of acquiescing in name changes and the use of the wrong pronouns and allowing the child to use toilets and changing rooms of the gender with which they identify. Boys can use girls' changing rooms and vice versa. Dr. Cass described gender affirmation as an active intervention in the life of a child, which may have significant impacts upon its psychological functioning and future outcomes. The Children's Commissioner has, unfortunately, been driven into the gender affirmation camp by her erroneous belief that the UN Convention on the Rights of the Child requires giving primacy to the child's right to do what he or she wants. I have discussed this with the Commissioner, and I'm afraid that I simply don't agree with her interpretation of the Convention. The alternative guidance drafted by Stephanie Davis-Arrey is firmly based upon watchful waiting. The first principle on page 16 states that children should be left to explore identity without being either shamed or affirmed. They should be free to express themselves as they see fit. The existing guidance asserts in two places that schools should or may adopt a watch and wait policy, but they are token assertions. The thrust of the guidance is gender affirmative. Social transitioning is described as a means of enabling children to explore their gender identity safely. It is not safe to encourage social transitioning. Social transitioning is a step towards medical transitioning. The Cass report stated, and I quote, "Those who had socially transitioned at an earlier age were more likely to proceed to a medical pathway." Members may have different views on this, but I am clear that children and young people should not be encouraged to move towards a medical pathway. No child or young person at a stage of life when they cannot know what they will feel like in 10 or 15 years' time should be guided along that route. The Minister will probably say that the existing guidance does not do that, but it does encourage social transitioning, which, according to Dr. Cass, is the first step. The existing guidance is muddled and contradictory, especially in relation to the use of toilets and changing rooms. Guidance on toilets states that staff should adopt a case-by-case approach, but that, and I quote, accessing the toilet which corresponds to their gender identity can be extremely important. CIPES therefore encourage schools to enable this wherever possible if asked for. A boy who identifies as a girl should therefore be permitted to use female toilets if he asks for it. That is what the guidance says, although a few lines up it also states that separate toilet facilities for boys and girls aged 8 or over must be provided. The guidance contradicts itself. In relation to residential trips, the existing guidance states that, and I quote, CIPES recommends that, so far as possible, trans children and young people should be supported to be able to stay in residential accommodation appropriate to their gender identity. Put bluntly, boys who identify as girls should be permitted to stay overnight in girls' dormitories. Then the guidance begins to equivocate by referring to the Keeping Children Safe in Education policy, KCSIE, and stating that in allocating sleeping arrangements, each child's sex is relevant. So what is the guidance actually saying? It then goes on to recommend discussion with the trans child or young person and their parents and with friendship groups. No mention, however, of discussion with the parents of other girls who may find themselves sharing accommodation with a boy. It is hardly surprising that some parents have expressed astonishment at this gross safeguarding failure. Maybe in practice it doesn't happen, but why permit such nonsense to find its way into official guidance? Compare our existing guidance with the recently published draft UK guidance on KCSIE. Paragraph 105 of the UK guidance states, schools must not allow children into toilets designated for the opposite biological sex. This includes where schools are responding to a request to support any degree of social transition for children who are questioning their gender. And paragraph 112 of the guidance says, schools must not allow a child aged 11 years or older at the start of the school year to undress in front of a child of the opposite biological sex to comply with their safeguarding duties. When responding to a request to support any degree of social transition, this must not include allowing access to changing rooms designated for the opposite sex. That is very clear, and it accords with the judgment of the Supreme Court last year, which also represents the law of Jersey. The proposed Jersey guidance states a little more succinctly, children have the right to single-sex facilities. This is vital for their safety, privacy, and dignity. Toilets, changing rooms, and residential accommodation must all be single-sex. Where a gender-questioning child feels uncomfortable, provision such as a third space can be made available. The proposed Jersey guidance is clear and lawful. The existing guidance is ambivalent and unlawful. Where the existing guidance states that the discrimination law entitles children to access facilities in line with their gender identity. That's at page 8 of the existing guidance, if anyone wants to look at it. That is wrong in law. Indeed, there are many misleading references to the discrimination law and its effect in the guidance. The section on admissions to single-sex schools is also wrong in law. The discrimination law does not require the admission to an all-girls school of a boy identifying as a girl. This is nonsense. I will not go into detail, but the same ambivalence can be found in the section on physical education and sport. I come to parents and their rights to be informed. The existing guidance states at page 22 that most parents will be involved in working in partnership with the school. But it also states that information about a child's trans status should not be shared without the child's consent. That is expressed as being an issue of confidentiality. Paragraph 32 states it is not obligatory for teachers to inform parents that a child is exploring their gender identity. Respecting the child's confidentiality means that staff may be occasionally required, and I quote, to use their legal names and the pronoun corresponding to their sex registered at birth. This seems an extraordinary piece of advice to teachers. You must use the birth names and pronoun when talking to parents and not let them know that those are not the name and pronoun used in school. In other words, staff are required to deceive the parents. That kind of deception seems impossible to justify in the absence of safeguarding concerns. The proposed guidance, on the other hand, states that involving parents should be the default position unless there are safeguarding concerns regarding the family. That seems to me to be a sufficient discretion without requiring staff to deceive parents. One thing that has puzzled me until recently is why adult members of the trans community are so exercised about this proposition. We all have had long emails from trans adults and from Liberate, the advocate for trans rights. I have been asked several times to withdraw this proposition. The proposition concerns schools' guidance. It does not directly affect the lives of trans adults. So why the passionate opposition? And I think that the answer is that they view so-called trans children as part of their own group. They want children who gender question to transition. But should they? This is more likely to be a passing phase than anything permanent so far as children are concerned. Do we want children to transition? If we care about children, it's a question to which we need to give an honest answer. The existing guidance equivocates because it was so influenced by the trans community in its drafting. Those on the other side of the argument were briefly consulted, but excluded from the working party. My honest answer is no, not because of any prejudice against the adult trans community, as I have made clear. They are absolutely at liberty to make those choices. My answer is no, because I don't want children to transition. It's a hard, painful, emotionally and psychologically difficult choice. It causes turmoil for parents. That's why children should not be encouraged to transition. Such choices should be made in later life. Social transitioning is an encouragement to medical transition. If children are not socially transitioned, 85% of them will desist. If not encouraged, children grow out of these feelings. The chief executive of Liberate tried to persuade me that that figure was inaccurate, but my reading suggests that she is wrong. She has confused desistance, that is, changing your mind at an early stage, with detransitioning, which is changing your mind after medical transition. She takes statistics from the CAS report which relate to patients after medical transition, medical intervention, and indeed very few of those do detransition. But academics looking at the picture before the trans ideology took root are broadly agreed that the average desistance rate, that is giving up on gender change, was 85%. That was under watchful waiting. If children are socially transitioned from early childhood, the latest comparative study shows that only 2.5% desist. That is the difference between watchful waiting and affirmation by social transitioning. It seems to me obvious that children should not be encouraged to go down a route of transsexuality. There is a line to be drawn, clearly, between supporting a gender-questioning child by listening, by trying to understand, by offering empathy on the one hand, and validating that child's beliefs by endorsing them on the other. The existing guidance seems to agree with that position that I have just outlined, but then goes on to get the balance completely wrong. The MOU checklist at Appendix 2 of the existing guidance, which says that it's a note of a conversation between a child and a supporting teacher, is a classic example of activist affirmation, endorsement, and validation of the child's belief. It is not neutral. It is encouraging the child down a transsexual pathway. It is just wrong. I think the proposed guidance, on the other hand, gets the balance right. I move the proposition.
Thank you. Is the proposition seconded? Well, we move to the amendment lodged by Deputy Gorst, and I ask the greffier to read the amendment.
Page 2. Substitute the word replace with the word review. After the words 17th of March 2025 with, insert the words the review to be undertaken immediately after the June 2026 elections and completed by 31st of December 2026, and to involve all interested parties, including parents of children potentially affected, in consideration of. After the words and to make, substitute the words this with the words revised guidance subsequently.
Deputy Gorst.
Thank you, sir. On the one hand, this is a straightforward amendment. Members will know that the existing guidance proposes a review, and I apologise to members for my report says May, but actually it's March, proposes a review of the existing policy in March 2027. What this amendment does is to say, rather than exchanging the proposed guidance in Deputy Balash's proposal and replacing the existing guidance, this keeps in place the existing guidance and proposes bringing forward the review that the department was already intending to undertake. It simply brings it forward a number of months. And why do I, sir, propose a review rather than the replacement of the guidance? Well, members who've been looking across the chamber during the course of this debate will have heard Deputy Balash's words about watchful weighting, and they will have seen the movements of the Education Minister, who believes that the existing guidance is sensible, reasonable, and is a watchful waiting approach. And so what I am seeking to avoid in suggesting that the answer is a review means that there is no predetermined outcome, there is no predetermined position, but that Jersey should do what it really often does incredibly well. It recognises that it is a small community and sometimes difficult issues must be addressed in an appropriate way for a small community. And my belief is that this issue is best addressed by the review that the Minister was proposing but brought forward in advance, so that those conversations about watchful waiting, about social transitioning, about how schools and teachers handle these difficult, complicated, but very personal and individual issues is best done through what has become understood elsewhere in other matters, a process of co-production, a process of listening and listening actively, so that we can reach a set of guidelines where there can be broad consensus across the community. Sometimes, sir, I wonder if I'm too hopeful. I wonder if I'm too naive, because all of the media that we receive from elsewhere, not here, but from elsewhere, is of a divisive nature, is of an otherness nature, is of a conflict nature. And in small communities, we must do all that we can to avoid such divisiveness, such exclusion, and it is in that spirit that I bring forward this amendment to seek to ask the Minister to bring forward his review, the review that the department has already proposed. There will be listening to counter voices. That's not inappropriate in subjects like this. But what a process such as this can do is to seek to ensure that those extreme voices are appropriately managed and dealt with. Those marginalised voices are brought into the conversation. The voices of parents, the voice of lived experience, can come together and hopefully out of this review bring broad consensus. As I say, there is no predetermined outcome. That would be inappropriate to suggest that there should be. But it is the only way I can think of that would bring together those widely divergent views and therefore help build a community of acceptance and build on what I think we do at best, which is bringing people together and solving our problems and disagreements in an agreeable fashion. And so, sir, I hope that we actually don't really need to have a long debate or a detailed debate, because those conversations should happen in the review process. And so, sir, I propose to members the bringing forward of the review that the Minister and the existing guidelines already suggest. I must also say that once again, I feel the pain of the Minister and his education colleagues, because they are somehow at the forefront of this a debate which elsewhere is much wider. We are only talking about guidance that teachers and schools will follow when children are questioning and how that should be handled. We're not talking about the curriculum or any other issues of school life. We're talking about guidelines to help teachers and schools handle well children who are questioning, and so that those children feel listened to and feel included, but at the same time, parents feel listened to and they feel included as well. So, I make my amendment. Thank you.
Thank you, Deputy. Is the amendment seconded? Deputy Rob Ward, I think you indicated that you wish to speak on the amendment.
Thank you, sir. So the amendment under discussion proposes accelerating the review of existing guidance relating to children and young people, and suggests that a specific document contained in the appendix of the wider proposition be considered as a key influential part of the review. It is important to begin by recognising that any guidance concerning children must meet high standards of care, legality and rights-based practice. Policy in this area must align with the European Convention of Human Rights, the United Nations Convention on the Rights of the Child and Jersey's anti-discrimination legislation. If we as an Assembly are to have any credibility when claiming to uphold these fundamental rights. These frameworks exist not as optional considerations, but as obligations that shape how we support, protect and include every child. Concerns have already been documented regarding material referenced in the amendment and the accompanying appendix, which the proposer of this amendment would have as a fundamental driver for the review. This amendment requires a specific consideration of the guidance imported from the UK pressure group be directly considered as a replacement document. Independent review of that document has identified significant issues, including the presence of language that could be regarded as harmful or discriminatory towards children. Further analysis has indicated that the document could not be brought into compliance with relevant legal duties without substantial reconsideration. Additionally, sir, it has been noted that the document does not include the necessary assessment of rights engagement or safeguarding considerations that must accompany any proposed guidance relating to children. And I would ask the proposer to explain his understanding of what safeguarding in schools means and looks like. Professional expertise plays a critical role in shaping our approach. The Children's Commissioner has highlighted several areas of concern referencing risks associated with the document in question. The role of the Commissioner is specifically designed to ensure that children's rights and welfare are placed at the centre of policy development. Such expert commentary provides valuable clarity, particularly in an area where precision and sensitivity are essential. It's also crucial that the current guidance already in place has been developed through a collaborative process. Representatives from education, schools, parents, and groups across the island have jointly contributed to its formation, including very differing opinions on these matters. This collaborative model ensures that guidance reflects broad professional insight and community involvement. Furthermore, the guidance is already scheduled for a review as part of the normal policy cycle. This review will consider new evidence, professional expertise and developments elsewhere in the British Isles. That wider context is also relevant. Earlier this month, the Department of Education in England published a draft of updated guidance related to gender questioning in children, and it is intended to become part of the statutory framework from September 26 in the UK. Officers within our own education service continue to monitor these developments closely to determine whether any aspect of emerging best practice, that's an important phrase, may be relevant to the future revisions here in Jersey. This measured, evidence-informed approach ensures that any updates are considered carefully and systematically without undue influence from politically motivated and ideological groups. At present, the existing guidance remains operational and focused on the principles of safeguarding, inclusion and pastoral support. I will deal with those when we get to the main debate, sir, because I think they are simply not interpreted correctly. It adopts a case-by-case approach grounded in careful professional judgment and maintains an emphasis on anti-bullying, well-being and watchful supportive practice. Its planned review offers the appropriate route for future refinement. That's the key. And sir, any minister taken in this role could decide to bring that review forward if they wanted to. But this amendment does not simply move that review. It conducts a review within the context of a particular document which has serious flaws imported from UK pressure groups. And that is an important part of why I would ask you to reject this amendment. And so, during the review, in bringing points together, significant procedural and substantive considerations arise in relation to the amendment and its documented references. Any guidance concerning children must be rights-respecting, evidence-based, legally compliant and informed by expert assessment. The existing framework and scheduled review process allow for this, ensuring that updates are approached with necessary rigour. We don't just import something en masse, which has not taken those considerations into approach. And so we're going to have long days, so I'm not going to go on too long. But so this amendment is much more than a simple review. It is a straitjacket for directing us to adopt an external policy that is fundamentally flawed, fundamentally misinterprets safeguarding, and removes the fundamental right of a child to have a voice in their own lives. I urge members to reject this amendment to the proposition. Its simplicity is not what is being proposed. Its simplicity is something that will extend the forum that has happened on this island over the last few months. And I want to add to my speech as a personal note that I've seen a community really put under strain because of the influence from elsewhere. This guidance has existed since 2016. When we do review this guidance, it's actually going to be difficult to find any of the problems that have been raised with it. We will be looking for them because it has had very little use in schools and there is no necessity for it. So I will come back to the selective interpretation when I come to the main debate. But sir, I urge members not to be convinced that this is a simple review. It is not. It is the next stage in undermining good practice, professionalism and genuine safeguarding and well-being of all of our children, even those who may be questioning themselves in whatever way they do. So we are here, and I as Education Minister want to support every single child in our school. I want to make sure they're safe, their well-being is looked after, that we can do all we can about bullying, particularly if they have any type of difference and they are and without ideological influence. So I urge members, please reject this amendment. Thank you, sir.
Thank you. Deputy Dublé.
Thank you, sir. I'm pleased to follow the Education Minister, and I endorse, I think, everything that he said. I think he made some very sensible points. And I'm grateful for that, and I know that the LGBTQ+ community in Jersey, of which I'm a member, I know that the community are grateful for the support of the Minister and government in opposing the proposition that's before us today. I'm finding this very difficult, sir, because a previous speaker mentioned that we should be respectful during this debate, but I really regret that this debate has been brought before us today. I feel very, very sad. I'm very disappointed and embarrassed, actually, for us as an assembly that we're even having to discuss this today. And I wanted to apologise to the trans community for anything that they hear which is hurtful in any way. I've already heard things that are hurtful, not just to the trans community actually, but people talking about attractive 16-year-old girls, which is just bizarre, quite frankly, bizarre, and has absolutely nothing to do with trans people. Sir, in terms of terminology, one of the things that has been affirmed is that there is no such thing as a trans child. And I wanted to clarify something, which was clarified to me because I asked this question. And it's worth reflecting, sir, that this area can be quite difficult to understand. If you're not a trans person yourself and you don't have lived experience of this, it can be really difficult to understand. And actually, I really appreciate the States members who have come and spoken to me and asked questions, actually from across all areas of the Assembly. And what I have noted, sir, is that actually the vast majority of members that have spoken to me about this are genuinely curious, want to make decisions that are compassionate, and have listened to me, and those people who have come to speak to me, and also who came to meet with the trans community, a meeting which was set up by Liberate. I found that meeting really enlightening, to see how many States members, again, all different types of States members, came to that meeting, and I know that the trans community there really appreciated being listened to. And Deputy Balash was there, and I could see that he was also listening. But in the guidance document that we are being asked to review, this amendment is asking us to bring forward the review of this guidance document. The word trans with a star at the end of it is used, and that indicates that it's an umbrella term, and that it includes children who are gender questioning. So we wouldn't necessarily define those children as trans, but we would recognise that they have questions about their gender, that they have identified themselves and that they have told an adult about. We wouldn't necessarily call them trans. So I think there are it's one of many, I think, misunderstandings inherent in the original proposition, and to a lesser extent in the amendment. Although I do acknowledge that the amendment is well-intended, well-intentioned, and I can see where the proposer of the amendment is coming from. And I know that this amendment was lodged, I think, on the 17th of March. There wasn't a lot of time, probably, to talk about this, but I would have really welcomed a discussion with the proposer of this amendment, which didn't happen before that was lodged, because I think we could have probably had some discussions that would have been helpful. One of the problems with this amendment is that, and the previous speaker did mention this, is that it presents all voices equally. And that is a problem because not all voices are equal, and not all voices should necessarily be given an equal platform. When we are talking about a marginalised group of people who deserve our compassion and our protection, why would we enable groups, and I want members to be aware that actually the United Nations has notified some of these groups as hate groups. Why would we give groups like that an equal voice when we're talking about the safeguarding of our children? Surely we want to protect our children from hate and from hate groups, and surely we should listen to the UN. So I don't agree with that part, and I also don't agree with, but I will come back to my point about listening to different groups, because I do think that some listening is reasonable. The Deputy Gorst's amendment still refers to the alternative guidance which has been put forward by the group called Transgender Trend. And the name of that group in itself tells you what their views are about the trans community. It's quite a dismissive thing to say, isn't it, about somebody's identity, that your identity is just a trend. And I personally acknowledge that trans people do exist, and we cannot ignore them. They're part of our community. Many of them are my friends. I have never been... Sorry, sir, I lost my train of thought there. I will go back to my point about the alternative guidance document that Deputy Gorse would like to be taken into account as part of his proposed review. And the reason why it is problematic that would still be included is because that guidance itself is hugely problematic. And similar guidance is in place in other jurisdictions. In fact, I asked some questions about what was happening in neighbouring jurisdictions because, as Deputy Gorse referred to, this debate has been carried out in other jurisdictions, and I think some really bad decisions have been made by other jurisdictions, which I really don't want Jersey to follow. And I know in Guernsey they have changed their guidance. It used to be quite similar to our current guidance. They have changed it. And I have a quote, sir, that I'd like to read out from the parent of a child who was a healthy, happy, gender questioning child under the previous guidance, which is similar to our current guidance. They were actually thriving in their school. They were getting understanding and support. They were getting compassion from their school. And since this new guidance has been implemented, I will quote, "The way my child has been treated by education is appalling. She has been segregated from her peers and it has affected her mental health. Prior to the implementation of the new policy, she was happy and affirmed at school. Now she is anxious and stressed about school events and has mentioned feeling suicidal. I have raised complaints about the way she is being treated and repeatedly requested a risk assessment that considers her mental health and the effects of segregating trans children, but the school have refused to provide it." I could go on because the evidence and the quote does go on, but I don't feel I'll have time to do so. We must think for ourselves here in Jersey. And this is something that has come up in previous debates that we've had recently, where we have shown that we can be independent thinkers here in Jersey. We don't need to follow any bad decisions that are happening in other jurisdictions. And so the fact is that this proposed review that would bring the planned review date forward by several months, it's not necessary because a thorough review has very recently, as the Minister said, is very recently being carried out. And the guidance that we currently have is quite recent. And I wanted to explain to members about the listening that has already happened. Because in the previous government, and I'm very grateful actually that the current ministers have continued the work of previous government in this respect. There's been a consistency there. In the previous government, I was approached by members of the group who also approached Deputy Balash and have informed his proposition. And I listened to them. I met with them. Deputy Jean also accompanied me to the meeting. And we listened to those individuals. And when I say listened, I mean really listened. I'm not somebody who entrenches myself in a political position just because I'm aligned with a certain group. I think members know me well enough by now to know that I question everything, and both sides of the argument is something that's been referred to. And I don't even think that's something we should be saying, because that is something that has been constructed by people who want to negatively impact human rights of a small group of people. I don't think there are sides to this debate. I think there is our community with experts, teachers, children, parents, the diversity of our community. And then I think we have outside political groups, because this group, they're not a Jersey group. They've come to us from, it's a national group. And it feels like an invasion, actually. But I did listen to them, because I do feel that people should be listened to. And although it was difficult, I was very civil, I was very respectful, I listened. I'm a good listener. Deputy Jean also listened. We asked gentle questions. And nothing that was said to me in those meetings convinced me that the approach of compassion and the approach in this guidance that eventually came out, nothing convinced me to do anything differently. I do understand that people have some fear around certain cultural changes that may be happening recently. So I can see that some people may be fearful of male violence in women's spaces. That's not fear of trans people. We all know that there is a problem with violence against women and girls in our island. So I can empathise with that fear. But what I can't do is reach the same conclusion that trans people are causing that violence. Because what one of the previous speakers described as letting a boy into a girl's changing room, actually what this guidance doesn't do is say that boys should be allowed in the girls' changing rooms. The guidance is about gender questioning children, of which, by the way, there are very few. We're talking about a tiny, tiny number of children, beloved children, who are beloved by their families and precious to their families. And I hope we can keep those children in mind when we have this debate today. I'm aware my time is running out, Sarah, and I'm trying to get all of my points in here. I feel that there is potentially a further compromise, and I did speak to the proposer of the amendment and the minister about this. I can understand the proposer of the amendment, I can understand Deputy Gorst's wish to find a compromise. I do think it's misplaced for the reasons that I have said. But I think there is a further compromise. What I would ask of the Education Minister, and I know he's already speaking, so perhaps he could ask an Assistant Minister, and this is something I've consulted some members of the trans community about. Given that there is already a review planned into this guidance, I think is it for May 2027? Mm-hmm. March 2027, okay. I mean, I think that actually we should just leave that be. But what the Education Minister could do, if he were minded to, he could offer a further compromise and say, we'll bring, I'm sorry if I missed it, if he did say that in his speech, and I'll let him clarify at the end of my speech, to just bring that forward a little bit. But what I won't agree with is that this alternative document by a hate group should be part of that review. I think it's reasonable to reflect on changing circumstances and laws internationally and bring it forward. I do have more to say, sir, but I'm not the main respondent, so I will have to sit down. But what I will say very quickly is feedback on the current guidance from teachers, and we've had this on email, so please look at your emails. The current guidance is balanced and non-challenging, and it has a significant strength in its balanced approach.
Thank you.
So will the last speaker give way to clarify a matter for me?
Deputy Dublet, do you give way to clarify a matter?
Yes, sir, but I reserve my right to respond.
Deputy Balash.
So Deputy Dublet has spoken of hate groups. Would she please say whether she is suggesting that the Women's Rights Network is a hate group?
Thank the Deputy for his question. I'll clarify that on my speech on the main proposition.
Deputy Scott.
Thank you, sir. I'm going to focus the speaking to the amendment because in a sense it does almost suggest it's going along the way what Deputy Dublet suggested might be a compromise, and I don't really believe that that is necessary or appropriate. In fact, I don't believe that's well advised at all. Because basically, this is an area in which people do hold strong views. And I liken it to one of those social media debates. I've actually said to another states member, every now and again I open the door and put my head in the oven just to feel the heat. But I'm not going to resolve anything. If I'm going to say, right, okay, let's review this, let's get everybody's views, I'm not going to get everybody to agree. And that's basically what this amendment is suggesting is possible, and I don't believe that is possible. I believe what is possible is to actually focus exactly on what this document is doing, what the context is, and what the context is in which people are objecting to it. And only on that basis may we be a little bit more comfortable about what it is doing and what it is not doing. I have, and I'm very grateful to the constituents who've come to me and spoken on this. I did have somebody come in representing the Women's Rights Network position. Now, in the past, I certainly have regarded myself as quite an ardent feminist, so I was interested to hear what they had to say. And then when they said that and gave me this kind of chart comparing this guidance with another guidance, I said, well, actually, I've read this document and much of it I don't find offensive. So just tell me the bits that really are giving you a problem. I'd like to review it. Never came back to me. Next thing, what do I know? They're pushing a document, a whole new document, a different document completely. My questions are unanswered. Instead, here's the document, and we think this is what you should have. I think that we need to actually come back to what is going on here. We're talking about the context, and it's not just how we define people, it's how we define things like guidances. Any one of us can look at something, whether it's a social media exchange, whether it's any document, and actually say, oh, look at this sentence, it's evidence of this. Well, yes, but but if you look at the context, it may well not be. And I would think that the proposer, like more than anyone, understands a bit more about context. So I'm going to come back to the actual document that's been issued by the by CIPES itself. If you go to page 8, if you go to page 9, you will see exactly what it is saying it's trying to do. And the way I will interpret this, and in fact, to some extent, it's aligned with some of the messaging that we are getting, that actually up to puberty, yes, gender and identity can be fluid. And indeed, one of the constituents I had who is a member of the trans fluid community said she didn't really understand that she was trans until after puberty. But that doesn't mean that fluidity doesn't exist in adulthood. I mean, just biologically, we all can have variations within us. And that may make us different from each other. And that can even happen in our brain structures. And this is where something called gender incongruence comes from. When your sense of self does not align with most people's idea of what is male or female, that is it. And you know something? There's a certain very, very small percentage of people who have this. But it's still not a problem. I mean, I've even been told I think like a man. I seem to think like a man. I talk like a man. Well, maybe I do, maybe I don't. But do I have a problem with that? Do I have a problem that a late civil servant used to address me as Mr. Moz Scott? No, I really do not give anything, sir. So, thank you for the raised eyebrows. But there is something else that actually affects a minority of this minority, and it's a condition of distress, psychological distress, which is called gender dysphoria, where that person, because of their gender incongruence, actually is in a state of psychological distress. We talk about safeguarding. We talk about letting children be children. Are you going to let children be in a state of distress if they've got this condition and ignore it? So this basically, I would say, is in the context of this actual psychological condition. And I would, again, refer you back to pages 8 and 9, which talks about it, and talks about what has happened in these cases is that some people who give medical advice and perhaps, and it's been very controversial. Indeed, I've even been asked questions about that at one of these schools' presentations about whether it's puberty blockers should be used. Now, that's just not happening here, but it has happened in other places, and it's very controversial. And that, of course, for many people is objectionable. I don't particularly feel I agree with it. Others will say it really is up to a medical professional to actually think, is this somebody that we can help in this way? But as the Minister of Education has said, it's not really something that is really happening here, or prescribing social transitioning, or actually saying, look, the best way to treat this person right now is in this way. So I do have a certain sort of, and I think a certain number of people that I've spoken to in the community, perhaps an element of bemusement, for some frustration, because there's a recognition that there is a minority and that there is a guidance that's come from somewhere addressing a minority, and is it actually solving a problem that's not there? But nevertheless, that potential situation could happen for teachers, and I believe that is the whole context in which this particular guidance has been prepared. So a number of the people that I've actually spoken to, the issue is not so much about whether a minority exists, but is it really a good use of states members' time to be discussing a particular minority or a particular document relating to minority? But here we are, and we are actually spending even more time on this. And because people are actually taking things out of context and pulling it in a much wider context, which I personally object to, which is about labelling people and saying, well, actually, no matter what people say about children, you only have boys or girls, and you will be this and you will be that, when in fact, maybe there is just this really small minority, and there is a potential of a minority within them who are suffering this state of distress. And maybe actually they do need safeguarding. And you have to think about, well, how are we going to do this? So I personally agree that this document, whether it should have been drafted or not, has actually considered the issue very carefully. And I just feel that you're going to now discuss people with, very kind of different ideological viewpoints about, how it should be said and crafted and that sort of thing. It's actually unlikely to get you very much further. I think it's more a matter of educating people about what this document is and what it does. I'll just move on, because I do thank the Deputy for giving us the opportunity to ask questions of Stephanie Davies-Arai, who was the author of this report. I did feel that my questioning was cut pretty short, and I'm sorry about that, because I just got onto the subject of brain structures and how it can affect people. And, and I was actually informed that, well, this could have something to do with hormone therapy. And in fact, my understanding is that research into this condition and into gender incongruence, they are more and more careful to use subjects that aren't subject to hormone therapy. So I'm not prepared to say that there is not this minority in existence, and this minority should not have some sort of awareness, and people dealing with them shouldn't have some sort of guidance. And by that I mean teachers, of course. The other element of safeguarding that I'm going to emphasise, and indeed I think this is what's relevant in terms of the Children's Commissioner, is this question of rights in the context of safeguarding, because there are parents who have very strong views about what children should be and shouldn't be. And maybe for some children, home isn't a safe place. And maybe some teachers have to deal with that issue as well, and therefore need guidance too, and those children. So I don't really, much as I totally respect how parents care about their children and their views, there are unfortunately some parents, and we don't know always who they are, and teachers don't always know who they are, who aren't so sympathetic to these things. So how are you going to have teachers navigate this particular minefield? Well, we come back to this guidance. And it does very much allow them to use judgment. You know, again, go back to these pages. It's not saying teach this particular ideology, tell these people to take puberty blockers. No, it does not do that. It tells them, you know, basically use some discretion. Be aware of the safeguarding. And I do remember, I'm almost surprised, although I'm sure the Minister of Education will come back to this at this point, because almost every time I hear him speak on this, he talks about the whole pile of documents that teachers have to have when they take kids away on some sort of away day about safeguarding, because that is such an important issue for schools. So, sir, in short, I will I remain in support of the position of the Minister for Education. Really, if we could just wrap this up and move on, I would think this would be great. Thank you.
Thank you, Deputy. The next speaker is Deputy Felton.
Thank you, sir. I did hear what the previous speaker said in relation to wrapping this up and moving on, so I will keep this very brief. But I did want to make a couple of observations, really, in response to what the proposer of this amendment said in his speech. He talked about his want of bringing people together and doing all that we can do to avoid such divisiveness. And whilst he was saying that, I was reading his amendment and thinking, my fear is that what this will do, if his amendment was adopted, would be extend divisiveness and fear and make this an election issue. And I really don't want that. Deputy Balash, when he was moving the main proposition, questioned why trans adults would be so interested in this. And Deputy Gorst mentioned that we should consider the views of people with lived experience. And the answer to Deputy Balash's question, I think, is that trans adults are so interested and so concerned about this because they are the very ones with lived experience. They are the ones that have been through the education system. They've seen what's helped them and what hasn't helped them. I've heard a loud and clear message from those with lived experience, from those people within the trans community, but also from parents of people within the trans community. And that message has very clearly been to support the Minister and the current guidelines. I don't think that this amendment does anything to bring people together. I don't think it does anything to avoid divisiveness, particularly ahead of the election. And I urge the Assembly to send a very loud and clear message in support of our trans community, a community of which I'm lucky to have trans friends and colleagues, and I'm proud to call myself an ally of our trans community.
Thank you, Deputy. So the Constable of St Martin.
Thank you, sir. So this speech I wrote earlier, it mainly addresses the main proposition, but also addresses the amendment. Sir, I, like many in this Assembly, have been troubled
Well,
by this.
the speech needs to be focused on the amendment.
Well,
Constance.
it's part of it,
Yes.
so it's, yeah, sorry.
Thank you.
It should, hopefully it's self-explanatory. So I, like many in this Assembly, have been troubled by this proposition. And we've all received numerous emails from both sides. Many have been heartrending from both sides. I do not believe it is the intention of members of this Assembly to cause distress, and I'm aware that this proposition has brought about a great deal of distress and much soul-searching. Sir, having read about and thought about this deeply, many may be surprised at what I'm going to say, but hopefully it may help other members who have struggled with this. Sir, I support the conclusions of the Diversity Forum and will be voting against the proposition and therefore this amendment. Many of my fellow members have already made a number of strong points, so I'd like to highlight something which really troubles me about this, proposition, which is that this proposition seeks to override the Education Department and make it teach guidance proposed by a backbench member of this Assembly with no clear methodology or assurance that it is objective. So the bringer of the proposition is a leader of a party that claims to champion the independence of the civil service as a core principle. If that is indeed a core principle, then the bringer of the proposition must surely know that what he is proposing, only months before an election, no less, is inflammatory and seeks to undermine the trust we place in our civil servants and their departments. We cannot replace carefully developed guidance with a document from a backbencher, especially when it seeks to impact children's education. Precedents exist for a reason, and any member, old or new, should understand this. I'm fully supportive of the whole... Am I fully supportive of the whole of education's guidance? No, I am not. Do I think it could be improved? Yes, I absolutely do. Which is why I welcome the review, which is already scheduled for 2027, and which, if I understand correctly, can be brought forward to 2026 by the new Education Minister, whoever that may be. Thank you, sir. I will not be voting for the proposition or the amendment for the reasons I've given.
Thank you, Conatap. Deputy Renouf.
Thank you, sir. I've deleted, members will be pleased to know I've deleted quite a bit of my speech because points have already been made, but I have got a couple of points which I hope will shed some light. And I'd start by saying that compromise is indeed always an appealing concept, and I'm a big fan of compromise. However, calling something a compromise does not make it so. The problem with this amendment is that it is an attempt to find a compromise that actually requires one side of the debate to concede the fundamental point. The review that this amendment proposes embeds the Treating Children as Children document as the central consideration, and it repeats one of the central talking points of the original proposition in terms of the reference to engaging with parents. In other words, it establishes the very bridgehead into education policy that those opposed to Deputy Balash's proposition are seeking to avoid. So I'm afraid to say that although Deputy Gorst frames this amendment to the proposition as a compromise, I don't think it is. I think it achieves by different means most of what the proposer of the original proposition intends, which is to ensure that an entirely different set of principles based in hostility to the trans community are explicitly to be part of the consideration in the new policy. So for me, there is no place in this debate for the Treating Children as Children document because it comes from this point of hostility. And I just draw attention to paragraph 1 of Deputy Balash's proposition, that the entire ethos behind the proposition is that being trans is a problem. Because if you read that, the proposition refers to, and I quote, the small number of children who suffer from gender dysphoria. I know that Deputy Balash chooses his words with care, so I presume the use of the word suffer was deliberate. Is gender dysphoria something from which one suffers? That is quite clearly turning gender dysphoria into a pathology, not an experience or an identity. This is the guidance that Deputy Gorst wants to explicitly be considered in the review. What is more, the underlying ethos of the treating children as children's approach is explicitly hostile to the idea of children's rights. I won't go into that in detail now because it'll come up again in the main debate, I suppose. But the final point I want to make is one that I don't think has been made yet, which is that Deputy Balash says the existing guidance is muddled, ambivalent, and equivocal. He used all of those words at various points. And that's an interesting interpretation. The way I read the same guidance is that it is flexible and sensitive. The guidance that Deputy Balash supports and Deputy Gorst wants embedded in the review aims to remove flexibility and sensitivity in favour of a rigid, one-sided ideological view. The very thing that Deputy Balash finds problematic in the current guidance is, in my view, its greatest strength. It is sensitive, it is flexible, it is cautious, and crucially, it invites teachers to make their own judgments in the full knowledge of the circumstances. And that involves the point about that brings in the point about involving parents, which is part of the amendment, explicitly mentioned in the amendment. And the contention here is the point about it not being obligatory to tell parents. Deputy Balash says it is impossible to justify deceiving parents, and I have to respectfully disagree. I'm grateful to a member of the trans community who met with me and Deputy Miles for providing me with absolute clarity on this point. I asked this person, actually not in connection directly with the proposition, whether they had experienced any problems as a trans person, any hostility. I was surprised to hear that they felt that they were pretty well accepted as an adult, but there was a caveat. This person told me that they were aware of 3 children who had been thrown out of their homes when they identified as gender questioning, gender dysphoria, whatever. I apologise if I don't get the words right. It is the serious issue that sits around this is around, unfortunately, very difficult circumstances that some children find themselves in, and teachers have to navigate their way through those difficult circumstances. And in those difficult circumstances, it is my view that what teachers need is sensitive, flexible guidance and the ability to interpret it in the way that they see fit. And that might involve, contrary to Deputy Balash's view, that might well involve, for the welfare of the child, not immediately telling the parents. And for that reason, I cannot accept the amendment, because it does embed the notion of treating parents as part of this, telling parents as a central part of it. So I think the amendment effectively attempts to slide the treating children as children document in by the back door. And I believe we should send a very clear signal that we don't want this ideology to be embedded in our education system, so I shall be voting on.
Thank you, Deputy. Does any other member wish to speak on the amendment? If no other member wishes... Deputy Messer.
Thank you, sir. I want to start by saying that I actually thought the speech given by Deputy Scott was, in my view, one of her best ones that I've heard in this debate, notwithstanding that she did end it by saying maybe it's an idea to wrap it up, and I actually have a lot of sympathy with that. However, I've decided not to play my part in helping to wrap it up, because I do think that it is important that for everybody out there in our community who is struggling with this debate taking place, that they ought to know that there are as many members as possible in this assembly who stand for them, believe them, and will act as allies in our capacities as states members. So I kind of do feel that it is worth putting that on the record. So when I was listening to Deputy Gorst make the proposition and reading his report, Deputy Gorst from time to time makes really good arguments in this assembly on various debates. I occasionally even find myself agreeing with him, on those very rare occasions. But what I've noticed about Deputy Gorst's arguments as a skilled parliamentary debater is often not what he chooses to say in his arguments, but what he doesn't say in them and what he leaves out. And I think that there are 2 points that he may well have left out that I want to ask him to address in his closing speech. And they are fundamental points which he hasn't addressed in his report or in his speech, sir. The first, sir, is whether the starting point of his argument, because you can argue that it seems like a harmless thing to do to bring forward a review, and that was the argument he was making. But what's the starting point for that? And does that starting point include a positive affirmation of the human dignity of trans people? Does it include that? Does it include believing that trans people exist? They have always existed, and they will always exist, no matter what anybody thinks about that. Their existence is simply a fact, and for a very, very small number of human beings, it is an innate human characteristic that some people are trans, and that's just that. Don't ask me about the science, because I don't know. All I know is that these people exist. I've met them. I'm friends with some of them. They exist, and that is the fact. But there are people, sir, who don't believe that. There are people who believe that it's a delusion, that it's a choice, or that it's a mental illness. And those people are wrong. They're not correct to think that. The evidence and the medical and scientific studies that have taken place prove that. So when Deputy Gorst talks about seeking broad consensus and seeking unity, how does he think that is achievable when you have one side who believes in the human dignity of trans people, and that being trans is an innate human characteristic, in the same way being left-handed is an innate human characteristic in some people, and on the other side, people who just don't accept that reality? How do we seek unity between that? And is it not better to accept that actually that unity is impossible and one side actually just needs to win on this? It is as possible, sir, if we were having a debate about what guidance should be in schools about the geography curriculum, trying to seek unity with the Flat Earth Society. It's not possible because the Flat Earthers are wrong. And we know that because we sent people up into space with cameras. We know the world is round. You cannot seek unity with that tiny minority of people who just don't believe in that, although I'm sure we've met 1 or 2 who we might assume to be members of the Flat Earth Society. And I would ask Deputy Gorst if he will clarify whether in producing this amendment, did he meet with any trans people to ask them whether this is what they believed would be helpful for them? I would like to know the answer to that, because I really struggle to believe that any of them want this to be prolonged any longer than it needs to be. So that's the first point that he didn't make in his argument, whether it's based on a starting point of accepting the human dignity of trans people, and explain how that fits into this idea of seeking unity with people whose starting point is that trans people don't really exist. The second thing he didn't really argue in his speech or explain in his report, and this is also fundamental, which is why is it that the particular alternative guidance provided in the appendix to the original proposition is deserving of credence? Because if you want to have a review on the guidance in schools, that's obviously a perfectly reasonable thing to have, and that does happen already from time to time anyway, and the minister's signalled his complete open-mindedness on that. It would be foolish not to periodically review these things, but his amendment doesn't make this a debate about having a review on the guidance. It makes it a review on the guidance, giving specific credence to a specific document that says specific things, and he didn't explain why it deserves that from us. And I would like him to explain why, because what I see in the appendix to the original proposition is a document that has not been co-produced, has not been designed in partnership with people in Jersey's community, with the people who it will directly affect, but a document written by UK activists with no specialisations really in this subject and who have not a day's experience in Jersey's schools. Why does their view matter? Why does it deserve credence? I don't think it does, sir. And there are, I think, two elements of the proposed alternative guidance, and I'll try to be brief, sir, because I will want to address this in the main debate when we come to it, that I think disqualify that document from being held in any regard by anyone who cares about the well-being of children in our schools. And it was interesting, sir, because I did attend the briefing from the author of the guidance, and I did push back on some of what she said, and I have to say that I found her very unconvincing, and I thought that her arguments fell apart when they hit reality. And the 2 points it makes in it, sir, the alternative guidance makes it compulsory to bully children when it comes to what names they're called. So children at school, for all sorts of different reasons, will have different identities and may ask to be called different things. So I ask to be called something different to my legal name, and no one seems to have a problem with that, and nobody at my school ever had a problem with it. But the alternative guidance will make it a requirement that if a child wants to be referred to by a different name, if it's for a gender identity-based reason, it must not be allowed to happen. So that's bullying children. Let's call it what it is. And that's why, that's one thing in that document which we should have no regard for. The second, sir, and Deputy Renouf referred to this point as well, is that it also makes it a requirement in some situations to expose children to harm by informing people about their status as trans people when they don't want that to happen because they think it might be a risk to them. That is unconscionable, and that is completely the wrong approach to safeguarding, and it makes me believe that the people who wrote the document actually don't really understand safeguarding at all, and that their entire angle is built upon their ideology, not reality and not evidence. So there will be more to be said in the debate on the main proposition. I put myself on record, as I'm grateful other members of the Assembly have done so as well, by saying that there is no negotiation to be had on the respecting of the human dignity of trans people. They are who they are part of our community, and we ought to love and respect them for who they are. And that is not a point to be negotiated with people who simply don't believe they exist. So will Deputy Gorst, in his closing, confirm that that's his starting point as well? And would he like to offer us an explanation as to how it's possible to seek unity with people who don't have a starting point of accepting that fact? And secondly, will he explain to us why, in a review that will happen in some shape or form anyway, it is vital that in that process we give credence to a document that wants to make bullying children compulsory and a requirement to put children in harm's way in situations where safeguarding would otherwise suggest that they shouldn't do that. And if Deputy Gorst can't provide adequate answers to those, as I think it's inevitable he won't be able to, then there can be only one solution, sir, and that is to vote against this amendment and against the main proposition when it comes to it.
Thank you, Deputy. Does any other member wish to speak on the amendment? Deputy Balash.
So I understand and empathise with Deputy Gorst's wish to find common ground and to encourage listening to alternative voices and other points of view. And in self-defence, I must say that I have tried. I asked to meet the Minister with members of the Women's Rights Network, but received no reply. I asked to discuss the revised guidance with the Minister and was rebuffed. I have met and found some common ground with the Chief Executive of Liberate, I have had friendly exchanges with members of the adult trans community and parents of transgender adults and tried to understand their point of view. The requirement or the need for trying to find common ground was, it seemed to me, underlined by the speech which members heard from Deputy Dublé, which seemed to acknowledge that not all people should be given an equal platform, and that hate groups, unidentified, should be excluded. I would actually agree that any hate group should be excluded from a process of consultation, but the Deputy was not willing to tell me at this stage whether or not she thought that the Women's Rights Network was a hate organisation. I hope she doesn't take that view, because from my experience it certainly is anything but. I have met 3 members of the Women's Rights Network Jersey, all of whom are sensible, moderate, Jersey-based women who feel strongly that the existing guidance of the Minister is not correct. I wonder whether they are people whom Deputy Dublé would exclude from any consultation which might take place. I had a great deal to say on this amendment, but I don't think I will say it other than to say that, in my view, the Minister is misusing the references to the conventions and to the law to justify his unwillingness to admit that his guidance has serious flaws. Deputy Gorst's amendment does not give me the result which, in my view, there should be, but it is a compromise which I am prepared to accept.
Thank you, Deputy. Does any other member wish to speak on the amendment? If no other member wishes to speak, then I call upon Deputy Gorst to reply.
Thank you, sir. It was always going to be difficult to sum up this debate because, as I said in my opening remarks, on the one hand, this is a straightforward, simple amendment which brings forward the review that the department were already proposing from March 2027 to post the election to be completed by the end of the year. And I still hold to that view. So I will not, and I do not let go of finding common ground. To my mind, that's what being in politics and leading a community is all about. There are some areas where finding common ground, as we've heard and experienced during this debate, are difficult. But I would not be being true to all that I believe if I didn't think part of the job of this Assembly is to seek and find common ground for the good of all islanders. And that's difficult. And we've heard many speeches about why common ground can't be or shouldn't be found. Some of them have been around the wording of the amendment, finding common ground by including the voices of parents, finding common ground by considering, and it does only say consider, it's not the central tenet, It says consider an alternative form of guidance. Finding common ground. And so that some members asked me a number of questions. Of course, I don't start from a position of negotiating around the dignity of trans people. Of course I don't, nor does the mover of the main proposition. Whilst this debate has been on, some members will have received email correspondence talking about what may or may not be happening in schools and suggesting that I educate myself. Well, I'm always open to being educated, so even at my age in life. But this is not about what's on the curriculum. This is about guidance. And we can argue, as I argued at the start, that we can see that to some extent that's slightly unfair on teachers and the education system, but that's where we are. And I haven't, in preparing this amendment, spoken to trans individuals about it. Some may say that that delegitimises the amendment. But I have had lots of parents contact me who were concerned about the guidance, were concerned about what may or may be happening to their children. And I think, and members may disagree with me, that is their right, I think that by bringing forward a review which is not predetermined will help to build common ground across our community. I can't see any other way. I don't agree that it prolongs any difficulties that some members of our community are feeling, as though the changing guidance was something hanging over their heads. Because a review is already planned to take place in March of 2027. And if we look at what is happening elsewhere, whether that's in the UK or further afield, these are issues which are being used to divide. These are issues which are being used to create otherness, to create division, and not to support and listen and help. And therefore I can only see the answer is to do what I think we do best in this community. And that's to come together, to listen to alternative views, and to work through them until we can get a guidance that has broad support. That might be naive, and I see my colleagues here believing it's naive. But I refuse to give up on hopefulness and building common ground. And I ask members to support the amendment. Thank you.
Thank you. Those members who are in the appel's called for, members are invited to return to their seats. And I ask the greffier to open the voting. All members have had the opportunity of casting their votes. I ask the greffier to close the voting. And I can report that the amendment has been defeated at 16 votes for, 30 votes contre, and no abstentions.
16, please.
Those voting for the Colotabs of St Lawrence, St Brelard and Grouville, Deputies Labby, Luce, Morel, Ayer, Gorst, Balash, Wall, Rose Binet, Miller, Tom Binet, Barbara Ward, and Deputy Andrews, and online, Deputy Moore.
We return now to the main proposition. Does any member wish to speak on the main proposition? Deputy Rob Ward.
Thank you, sir. I think it's traditional for the minister to speak first. It's quite handy as well. Thank you, sir. So I am speaking to oppose P14 2026. This proposition asks us to instruct the Minister for Education and Lifelong Learning to scrap the current government of Jersey Trans Inclusion Guidance from the 17th, updated on the 17th of March 2025 and reviewed at that time, and replace it wholesale with a document titled Treating Children as Children, a safeguarding approach to trans identity, children and adolescents in Jersey. And I make that point just to be clear as to where we are with this proposition. It sounds procedural, sir, but it is not. It is a fundamental policy substitution from guidance developed within our statutory frameworks to a document authored externally. And the amendment to allow minor changes does nothing to address the fundamental effect of adopting the document suggested by the proposer, whether that amendment is accepted or not. And that document, sir, is framed explicitly as rejecting in a social justice, diversity or human rights framework in schools. I'm going to read that again, sir. The document is framed explicitly as rejecting a social diversity or human rights framework in our schools, and even asserts that the voice of the child needing to be central is not appropriate in safeguarding. Let me be clear, sir. Safeguarding is non-negotiable. Safeguarding in Jersey is grounded in Jersey law and our Children and Young People Law to 2022, our Keeping Children Safe in Education Guidance, our Human Rights Jersey Law 2000, our Discrimination Jersey 2013, and our commitments under the UNCRC. And safeguarding is the heart of day-to-day practice of teachers and all support staff. The current SIPES transition guidance is explicit about those foundations and scope. It is non-statutory. It excludes medical decisions. Nobody under the age of 18 can get any medical intervention in Jersey. That is a key point, particularly from the proposer's opening speech. And it is designed to help settings keep children safe, reduce bullying and harassment, and comply with Jersey's legal duties. By contrast, sir, P1426 directs us to insert a position paper unreviewed by our Education Department, not produced through professional processes, and ideologically framed as departmental guidance for every school. The existing guidance is professional, scoped and aligned to Jersey law. The SIPES guidance begins with principles we should all share. Every pupil should feel safe and treated with respect. Schools must comply with Discrimination Law 2013, Human Rights Law 2000, Data Protection Law 2018, the KICSI, Keeping Children Safe in School, a statutory set of guidelines, and the UNCRC. I repeat those because they are so fundamental to what I'm talking about. It recognises that trans identity and gender questioning children constitute a small but potentially vulnerable group in our school communities. From the Jersey Census 2021, 0.2%, and sets practical steps to keep them, all of those pupils, safe. Crucially, sir, the guidance states medical decisions are outside school and therefore excluded from its remit. That is a vital point when we look at this guidance. It adopts a genuine watch and wait stance against pressure in either direction. I simply do not agree with the interpretation that's made of that. The current guidance also emphasises behaviour standards, anti-bullying measures and case-by-case professional judgment with parents involved unless there are safeguarding risks, all squared within current safeguarding best practice. On contentious issues such as toilets, and we seem to be obsessed with toilets, it seems, changing rooms and residential trips, the guidance proposes a case-by-case assessment and sanctions for inappropriate conduct. As someone who's taken many school trips, sir, on island and abroad, I know and understand that this is a normal process for every child and every risk assessment document. I've been taken 50 children to foreign cities on many occasions and carried the 2 lever arch folders of risk assessment and assessment. I recognise how difficult that is and how thorough that assessment would be. So that it promotes privacy options for all pupils, not one group at the expense of another. And that is responsible. Professional guidance for real schools, real families and real children. It is reviewable and explicitly opens to future updates as evidence and case law evolve. It is a non-statutory guidance. We can change it. So it is important to recognise that the replacement proposed by P14 departs from Jersey children's rights approach. Appendix 1 of the document that the proposition would impose opens by instructing schools to set aside a human rights framework and declares that placing the child's voice at the centre is not appropriate in safeguarding. Fundamentally wrong. That is incompatible with our embedded children's rights approach, and so many of our schools now have children's rights awards from the UNCRC, and I'm extraordinarily proud of them. With the Articles 3, 5, 12 and our local practice of participation and non-discrimination in decision-making affecting children. It replaces professional curiosity and inclusive practice with categorical prescription. For example, rejecting school-level case-by-case work where professionals are involved and discouraging respectful language accommodations that many schools use to de-escalate conflict and support pupils' well-being. The de-escalation of conflict is an art form when you see it happening in schools. This is a remarkable process from skilled practitioners. We cannot undermine that with prescriptive language and prescriptive rules. So the document suggests it is not child-centred safeguarding, it is political doctrine presented as guidance. The position leans on UK legal positions and advocacy claims that do not map to Jersey. The report invokes the UK Supreme Court decision for women in Scotland versus the Scottish Minister to assert rigid outcomes in single-sex facilities and changing room, extrapolating that Jersey must ensure identical application. It even cites Jersey and Guernsey law review articles to suggest UK rulings should also apply to Discrimination Law 2013. But Jersey is not governed by the UK Equality Act 2010, and our Assembly legislates for Jersey. Our courts and guidance must be read through Jersey statutes and our constitutional position. The SIPE's guidance approach to consider sex as relevant, to ensure safeguarding obligations are met and to use risk assessments and reasonable adjustments is consistent with Jersey law and the duties we already carry. We should be extremely cautious about using selective UK judgments or external advocacy to override our departmental practice without due process. So when addressing how we support children in these areas, we must keep nuance and avoid absolutism. And so the propositions report criticises SIPE's guidance as activist, claims it promotes social transition and asserts numerous legal and scientific conclusions in categorical terms. Sir, I strongly refute this assertion. The SIPE's document already states watch and wait, case-by-case support, and that medical decisions are outside school. That is a very important fact in the context of the guidance has been developed, in which context of the guidance has been developed. It stresses anti-bullying behaviour, behaviour standards, the bread and butter of safeguarding. Furthermore, where the replacement document argues, gender identity is not factual, that children should never be referred to by preferred names or pronouns, and that schools should reject terms like LGBT because they confuse two different issues. It is prescribing cultural war language rather than equipping schools to diffuse conflict and prevent bullying. Our staff need tools to meet children where they are. de-escalate and keep everyone safe, not impose ideological absolutes. And so the concept of meeting children where they are is so important if a child is developed in any way. The SIPES guidance acknowledges uncertainty. It cites the CAS review's warning about polarisation, and it is reviewable. And that is what responsible guidance looks like. The proposed replacement does not offer that balance. It offers inflexible ideology. If members have genuine concerns linked to the guidance in schools, there are practical improvements we can and should support without overturning departmental guidance in favour of an external manifesto. The review in March 2027, sir, will be quite a difficult one, I think, because there's been so little use of the guidance and there are so many small numbers there, but we will continue to look. And if there was an issue, sir, I can absolutely confidently say in our schools that the guidance did not meet it, it would immediately be reviewed by the department, because that's what safeguarding is. Safeguarding is an ongoing, iterative process with the child's safety and well-being at the heart of everything that we do. High quality staff training in KICSI, anti-bullying, peer-on-peer abuse and confidentiality and information sharing are some of the ways in which we try to improve how teachers can be equipped to deal with these situations. Facilities planning to ensure privacy for all pupils, single occupancy cubicles, accessible toilets and clear behaviour policies for inappropriate conduct in any facility. So at the beginning of my time in this role, when we started to get the influx of pressure from the groups from the UK, I had a wonderful time going to visit toilets. Marvellous experience, going around all of the schools visiting their toilets, speaking to young people about their toilets. I was living a dream, sir. And what we got from our secondary schools, where they've replaced the boys and girls toilets, which a lot of children did not like because they were just open access and there were a lot of bullying occurred, with cubicles with floor-to-ceiling doors, some of them with sinks inside, much more dignity for people to go to the loo, children actually using the toilet at school, with hand washing facilities outside, and the ability, sir, to supervise those areas. Because as a male member of staff, you would not go into the female toilet. It's the last place I'd want to go, and vice versa. But by standing in the corridor and having these open facilities, you can supervise and you can make sure that children are kept safe. That has been used and weaponised by certain groups as a sort of, we are promoting trans children. It is simply inaccurate. And we need to keep sight of that. So that I've said about residential chips, safeguarding first. So I'm sorry about going on, but I really do want to make clear the reality of what this guidance does. So there are significant risks in adopting the appendix proposed as departmental guidance. Adopting the replacement text would downplay children's participation in rights decisions affecting them, contradicting our children's rights direction and policy practice. It would confuse staff by mandating categorical language positions that conflict with existing anti-bullying, inclusive education principles and professional discretion. It would increase stigma and the likelihood of bullying of a minority cohort, precisely the opposite of what safeguarding aims to achieve. It would invite legal uncertainty by asserting UK-driven interpretations onto Jersey frameworks and replacing departmental guidance developed under Jersey law with an external advocacy document. So safeguarding is about adult vigilance, professional judgment, clear behaviour expectation and protecting all pupils from bullying, harassment and abuse. The existing guidance talks about exactly that and does so within Jersey's statutory context. We do not address our improve safeguarding by importing a politicised document that begins by setting aside rights and children's voices. So our responsibility is to keep Jersey's children safe, respected and able to learn. Our schools need guidance that is practical, lawful, balanced and reviewable. The current SIPES guidance is that non-statutory, clear on scope, aligned to Jersey law, anti-bullying, privacy-minded and case by case. P14 will replace that professional guidance with an externally authored position paper that sidelines children's participation rights, mandates ideological prescriptions and misapplies UK legal arguments to our Jersey contacts. That is not safeguarding, sir. That is politics. For the sake of our pupils, our teachers, and the integrity of Jersey's children's rights journey, I ask you and urge you to vote against P14. Thank you, sir.
Thank you, Minister. The next member to speak is Deputy Stevenson.
Thank you, sir. And I'm very pleased to follow the Minister. I want to open my speech with a thank you to Jersey's trans community, to their families, their friends, to their allies, and to all who have supported them, particularly in recent months. And that includes representatives from Liberate, both here in Jersey, and I believe we have a representative of Guernsey's equivalent charity who's also travelled to the island today for this debate, so thank you for their support also. I cannot begin to imagine how difficult it must be to have a very private aspect of your life publicly discussed in this way, and even more so to have had this debate delayed more than once, effectively hanging over a community for that time. But many of these members of our community have taken the time, and some have really gone out of their comfort zones as well, to try to help States members better understand what we're considering today and the lives of those who it impacts on. That can't have been easy, so thank you. We appreciate you, we respect you, and we support you. In so many ways, I wish we weren't having this debate here today, but given that a proposition was lodged and thus has already stirred up so much public debate, then I think it's important to be able to put on public record today that those people in our community, those very valued and important people in our community, for whom this has been an extremely personal and potentially difficult experience, have our support. As others have said, we shouldn't forget that we're talking about real people here today, real families, real young people, real adults who were once those children, and who may well be listening to this debate today, or perhaps even joining us in the States Assembly. Yesterday, Deputy Dublé sent us all an invite to a meeting of the CPA BIMR LGBT plus network. Catchy title when it's all put together, isn't it? Unfortunately, I was unable to attend that meeting online last night, but I mention her invite because the email included within it a definition of what an ally is. And it said, an LGBTQ plus ally is someone who supports, respects and advocates for the rights and well-being of LGBTQ plus people, even if they are not part of the community themselves. I would hope that as an assembly we can send a very strong message here today, and I think we're already starting to, that collectively we are allies. I know that I certainly am. And I want to now take a moment to draw members' attention to the comments lodged by PPC on behalf of the Diversity Forum on this matter. I chair that subcommittee, and as a group of members from across the Assembly, we're committed to working together to improve diversity and inclusion. We discussed this proposition and there was unanimous agreement among all members that we wanted to lodge comments reflecting our position. And that position is that this proposition works against the very principles of diversity and inclusion that we're working towards, and instead risks having an exclusionary impact on a small group of individuals. We have full confidence that the inclusion guidance currently in our schools is reasonable and grounded in evidence around what is best for all children. So I've considered this proposition as chair of the Diversity Forum. I've also obviously considered it also as an individual member, but also particularly as someone who is a parent myself. And I've done so by comparing both the existing and the proposed guidance, because after all, it's the guidance that we're focusing on here today in the proposition. And the current guidance opens with the words, "Everyone deserves to be valued and treated with respect." I couldn't agree more. And the current guidance goes on to state that it's been written in line with the UNCRC, particularly supporting the underlying principles of Articles 2, 3, 6, 8, 12, 16, 17 and 28. it goes on to say, in addition to this, Articles 28 and 29 are prevalent in supporting all children in their education in respect to their talents and abilities. Articles 12 and 13 are of particular note for this guidance, with the voice of the child needing to be central to decisions that are made in conjunction with Articles 24 and 27 for a child to have their medical, physical and mental health needs met. I'd like members to compare those statements with the Children's Rights Impact Assessment, which has been lodged alongside the proposition from Deputy Balash. In that assessment, Articles 3, 5, 14, 19 and 36 are ticked as being relevant, nothing else. Non-discrimination, respect for the child's views, right to an identity and freedom of expression have not been considered relevant by Deputy Balash. That's not that they've been considered and maybe there are implications on both sides. Not relevant at all. There's no tick in any of those boxes. Nor has the right to education and the right to health and health services. Instead, the Deputy's career focuses on the rights of parents and of adults throughout, and no children or young people have been consulted in the development of the proposition. This approach is disappointing, to say the very least. And I would challenge the Deputy to go into any of our schools in Jersey, and that includes primary schools, and try telling even the youngest of students that he doesn't think that these rights are relevant. I know for a fact that there would be a queue of children and young people lining up to set him straight because they know their rights and they've been taught so well at their rights respecting schools. I'm lucky enough to have some of those young people in my own life, and believe me, I get regular reminders about the rights of children should I ever need to be reminded. In preparation for today, I had an age-appropriate conversation with a young person in my own life about what we were going to be discussing today, and I gently inquired about their knowledge and understanding of trans matters and their views on how such matters should be approached in school. I'm not really sure what I expected, but I didn't expect the conversation to be as simple or as short as it was. And I'm trying to choose my words very carefully because it's certainly, I'm not wanting to be dismissive in any way at all, but for them it really was such a non-issue. And the message was quite clear that it's us adults who are overthinking it. They are tolerant, supportive and respectful without even having to try. They are the true allies. Also, in preparation for today's debate, I spoke to constituents, and that includes those with lived experience and their families. And one such person explained to me how well their young person was doing, and they said, some of the credit for this goes to the wonderful education and health professionals we have met and who have supported on the way, who have both challenged and supported us. And I want to share a quote from that person as well. And the quote goes as follows: "Personally, I think the challenge young people are making to our rigid conceptions of gender and how society functions are interesting and hold much potential for undoing the harm created by the existing dominant gender ideology, a function of patriarchal institutions that creates emotionally illiterate, entitled, and often violent men. This is an irrefutable truth made clear in our crime statistics. We have to create space to listen to young people, not cut them out under the guise of an adult safeguarding lens. Why does the proposer feel it is okay to pick up the agenda of this group, ignore professionals and the law, and use his power against one of the most vulnerable populations in our community? What is the underlying fear here?" And that's the same message, again, that comes back from the young person that I spoke to. What exactly is the issue here? So to turn to the guidance itself, as I say, I've read both a number of times and considered them and compared them. And I couldn't help but read them both through that lens of being a parent. The existing states, many Jersey schools and educational settings are already working to ensure that the school environment and curriculum celebrates similarity, difference and diversity such that all children and young people see themselves and their families represented and valued. This guidance provides information on how to ensure trans members of the community feel equally welcomed, represented and safe. So that's the kind of schools that I want my children to be in. The current guidance talks about having positive relationships with parents and carers, access and safety for all, treating the welfare of trans young people in exactly the same way as others. It talks about case-by-case basis, treating each child and situation individually. It talks about a culture which celebrates diversity and where all children, irrespective of their characteristics, are valued. Where systems and support services are in place to support vulnerable children. Where effective bullying and equality policies are adopted across the whole school community, which challenges prejudicial behaviour, including transphobia, sexism, homophobia and biphobia. And it talks of a curriculum which provides children with the opportunity to challenge stereotypes and avoid making assumptions about sex, gender, gender identity and sexual orientation. Sir, that's the kind of system that I want my children growing up in. And crucially, it provides practical examples, tools and approaches for teachers and schools. The proposer claims that the current guidance is muddled and confusing, but sir, I think he's reading the wrong document, because actually it's his own proposed new guidance which is full of gaps and contradictions, and it contains very little practical advice or guidance for schools, just a list of rules about what schools should not do, much of which directly contradicts the values of our modern, diverse and tolerant community. It talks about rights being gained as a child reaches adulthood, a direct contradiction to what we are teaching our children every day. And I'm not sure I have the time, nor I'll admit the patience, to fully go into the claim that education for children must be grounded only in science and facts. There is so much more to the education that I want for my children than just the science and the facts. As a parent, I want my children to be exposed to a diverse, interesting and thought-provoking mix of education, which of course does include science and facts, but also interpretation, values, expression, challenge, politics, culture and much more. Sir, I could go on, but I think I've made my points. This proposed new guidance is not fit for purpose and serves only to feed a negative narrative, not to help support vulnerable young people, their families, their peers and their teachers. It does not put the child at the centre of anything, does not respect the rights of the child and does not uphold many of the values which I believe are important in today's modern society. By contrast, the existing guidance has been developed in partnership with key stakeholders and, by all accounts, because I have spoken to those involved in putting it together and implementing it, it is doing its job well. This proposition is therefore, at best, completely unnecessary. At worst, it's a divisive tool which attempts to make a political football of a small, potentially vulnerable part of our community, and I would urge members to reject it on that basis. Sir, I'd like to finish on a positive note. On Friday, I had the pleasure of attending the DIFRA Awards hosted by Liberate Jersey. 4 states members, all of them women, were shortlisted for awards at that event for their positive contributions to the principles of diversity, inclusion, fairness, equity, respect and acceptance. Deputies Helen Miles, Ina Gardner, Beatrice Porre and Louise Dublé. Sir, this Assembly is coming to the end of this political term, and the approach embodied by these women and many others in this Assembly is what I want this Assembly to be remembered for, not for the approach of this proposition.
Thank you, Deputy. Before I move to the next speaker, there is a point that I wish to clarify with you, Deputy Balash, and that is your amendment to your own proposition. Because if you recall, you didn't want to deal with your proposition as amended at the start of moving that proposition. So I'm afraid it's our fault we omitted to remind you of that. So do you wish to move the amendment to your own amendment to your proposition?
I share your responsibility, sir, for omitting to draw your attention to it. Can I solve the problem by moving now that the First Amendment be adopted and allowing the debate to continue on the basis of my proposition as amended by that amendment?
Thank you, Deputy. Are members content for the proposition to be debated as amended by Deputy Balash's first amendment? I'll ask the greffier to read the amendment, I think, before members decide.
Page 2, after the words accompanying this proposition, insert the words subject to any minor modification that the Minister may deem appropriate.
So do all those members get to speak again then?
Well, that's that is a difficult procedural question, but are members, well, does anyone member wish to speak on the amendment to the proposition? Members content then to, Deputy Scott? No. Members content then that the proposition is to be debated as amended by Deputy Balash's amendment? Thank you. Grateful. Very well, then the next speaker to speak is Deputy Gardner.
Thank you, sir. Thank you, sir. And as Education Minister walking out, I would like to... No, it's absolutely fine. I just actually would like to please to speak after the Education Minister and Deputy Stevenson, because they said lots of things that I wanted to say. And I would like, in this case, concentrate my speech on different aspect that hasn't been raised much. It was raised. Living as part of a minority group, general experience, be a minority, it can be difficult. Not because of people who they are, but because how societies are structures and how society chooses to respond to differences. And when we are here debating and we are thinking to debate a proposition that single out very small and vulnerable group of children, we are not making their lives safer. We risk making them harder. As someone who is part of an ethnic minority, I have at times been on the receiving end of abusive language. And I know personally how quickly words, attitudes, and assumptions can make feel excluded and unsafe. And this is why it matters. We know that Jersey is a small community, and our policies are not abstract. Our policies felt immediately, personally, and often really deeply for the groups that have least voice. As Deputy Scott, I did the same. We had a conversation. I did the same with my constituents and asked, this is the guidance. Find me paragraphs in this guidance that's saying what you are saying to me. Not what's sound bites on the social media, not something that you've heard on around the dinner table, but somebody mentioned here in this guidance. And I'm really pleased because we started, Deputy Louis Doublé and led on starting developing this guidance, but I remember we had this conversation and I just read a couple sentences, the beginning of this guidance. Globally, the trans community still accounts around 1% of the population and a target of bullying, harassment, violence that leads to increased likelihood of negative mental health outcome. It's in our guidance. Positive messaging is not the same as actively encouraging pupils to identify as trans. It's in our current guidance. The target, using techniques such as conversation therapy to change a pupil's gender from the one to which they identify is unsafe and unacceptable, and it's again in our guidance. In recent years, there has been an increase in the rhetoric surrounding gender identity. Much of this rhetoric is divisive, politically fueled by both social media and mainstream media. This has led to the increase in hate crimes against trans people, This is from our guidance. This proposition, whatever the intention, risks increasing stigma, fear, isolation for a very small group of young people who are already navigating complexity in their life. And this is where we should pause. It is about listening to children and not silencing them. It's about trusting our professionals and not replacing them with politics. It's about building a system that works for everyone. And it's not easy. It's not easy when we have so much difference, how we actually embracing the difference and making us, because each difference bringing different perspective and can bring us stronger. Let's all be clear. I started speech and I'll finish speech with this. Minority life is not inherently hard. It becomes hard when the systems, attitudes, and environments are not inclusive. To say that in Jersey every child matters, it means that no child should feel that they are the problem to be managed rather than a person to be supported. So today we have a choice, from my perspective. We can choose the path that risks increasing stigma or isolation, or we can choose a path that reflects the kind of Ireland we want to be: fair, inclusive, and respectful. Thank you.
Thank you, Deputy. The next member that I have to speak is Deputy Scott. Deputy Scott, we're approaching, 10 minutes before 6. Will that give you sufficient time for your speech?
Yes, sir. I think sometimes I've actually mentioned in debate the need to have propositions addressed things at the right logical level rather than conflate issues. And what we have is a conflation of issues, I believe. It's not so much safeguarding. I think we all want children to be safeguarded. But there's a kind of conflation of whether trans people exist before puberty, I think, and how you really deal with them. I've actually heard some amazing speeches. Deputy Stevenson made a very good speech and mentioned the subject of fear, and I think that this is a key issue here. And I'm just going to canter through some of the fears that I believe are relevant to this debate. And one of them is the fear of the trans community that their whole existence could be denied, is being denied. And I think that this proposition just confirms that fear, unfortunately. And there's also the fear of, I've had the mentions of things like conversion therapy, where, okay, biological sex exists, but if people start showing kind of like differences that they don't feel like a man or a woman, or they don't get attracted to men or women, that actually they need some sort of therapy to make them be like all the others. And I personally feel that's rather abhorrent, sir, because I do believe there's lots of varieties of people and that there's lots of space that we can make for them. And then there's this fear about actually what happens if you don't have single sex segregation, and the fact is horrible things like bullying and rapes can happen in single-sex toilets, and it can be inflicted by people of the same sex as each other. And what the Minister of Education has said about how this has been considered and is being approached more in the way in which we design safe spaces is perfectly valid here. I don't believe that regression in terms of saying, right, let's put this lot in one kind of like pen and this lot in another necessarily addresses the issue. There was indeed a certain amount of sensationalism in what happened in Scotland, where apparently somebody masquerading as a trans woman or went into women's prison and there was some sort of rape. I don't actually think that was a real, trans sort of thing. This was an abuse of an actual situation, and but it has played on these sort of fears that have gone against a certain community and has been and actually has caused some prejudice against them. And I'm afraid all things can be abused. We need to accept that one person doesn't represent all. I'll move on to the subject of just labels. I mean, actually, I've been quite old-fashioned here. I've been totally irritated by the word they when you're talking about single person. But at some point, and I was doing this when I was talking to the trans constituent, who is so kind and tolerant of me, because I know I'm probably, tread on every single woke minefield that there is. I can't help it of a certain age. But whilst talking to her, I realised that when it comes to pronouns, I actually speak languages where plurals and singulars get mixed up with even the term. I even believe Sherry does that. She is I and we, or perhaps. So I found myself thinking, well, is it really such a big thing? But I'm moving on to the subject of vulnerability. And one thing that lawyers often talk about is when you commit some sort of, damage to some people, that there's something called the weak skull argument, that basically if they've got a weak skull, you don't say, well, they're just, they're more vulnerable than others. Let's just treat everybody the same. We don't, that is not what we say. We say you've actually got to realise that people actually are who they are and they're fragile, and you need to, to basically do this safeguarding whoever they are. And the last thing is about, this fear of pushing an ideology in schools. But I believe that this is pushing an ideology too. So this is exactly what this proposition's doing. But I do believe if teachers are actually behaving in an inappropriate way in any sense of schools, that actually members of the public should be able to complain about them. And sir, I do believe that a public services ombudsman would be jolly helpful there too. Thank you, sir.
Thank you, Deputy. It's now
Propose the adjournment, sir.
the adjournment's proposed. The member's content to adjourn. Very well. The state stands adjourned until 9:30 tomorrow.
Just remind everyone that we have the CPA AGM starting in here and then finishing